All right. Blessings, fam. This is Grace Levi. And guess what we missed? If you did not miss it, I missed it. Today we're going to be streaming defense attorney who filed lawsuit against Fulton County DA Fani Willis takes the stand. So we're going to watch this together. As you know, we keep our eye on what's going on in Fulton County, Atlanta, especially Fulton County, because they keep us entertained. All right. So today we're going to rewatch this. These two individuals I love, and I would put both of them, but I'm just going to put right now Miss Ashley Merchant. And this is who we'll be seeing in action tonight. Okay. I will hope Miss Fannie Willis takes the stand, but you never know. So what we like you guys to do is get in the comments. Feel free to be. We want you guys to, communicate. Tell us how you feel about this. And let's get to it. I'll be in the comments with you guys. Let's shout out to Channel 11 Live. Okay. This was streamed today. All right. Also, shout out to my Rumble family. I don't know if you were able to see this stream. That's why I put it up because I think it's very important for everybody to see this. Let's see, can we get to? I don't want to miss a minute.
Counsel for the plaintiff is here in the form of Mr. and Ms. Merchant, and that the county and the remaining defendants are being represented by the county attorney's office in the form of Mr. Bowman and Ms. Monroe. So where we left off, I think, and then then y'all can tell me where we need to pick up if it's different, is that the plaintiffs had rested their case in this as to the initial portions of demonstrating, of offering evidence in an effort to demonstrate that the Open Records Act had not been complied with. And what that left remaining was the issue of, if in fact there is a violation of the Open Records Act, what steps or remedies does the plaintiff seek? And there were sort of two things that were left open. Number one was I requested clarity from the plaintiff if it was solely a matter of demonstration of damages, attorney's fees, et cetera, associated with efforts to secure the information that was requested, or if there were still outstanding matters that had not been produced for which the plaintiff was still seeking injunctive relief. I think initially, Mr. Merchant had indicated that they believed they'd received everything, and then subsequently, as I invited the parties to do, Mr. Merchant advised that upon review, it appeared that there were still some outstanding matters. That's where I think we left off, with the expectation that we would return today and begin to address those issues associated with possible remedies, assuming if in fact a violation has been proven. Last thing I'll mention, there had been lots and lots of people that were being subpoenaed. There'd been some sequestration, that sort of thing. As far as I can tell, other than perhaps calling Miss Merchant as a witness, those people, there's not a sequestration issue currently pending. Are we all in agreement on that for now?
Yes, sir.
Okay.
Yes, Your Honor.
Excellent. Okay. So with that, I'm going to throw it over to Mr. Merchant, Ms. Merchant, if you want to tell me where we are. And I did receive, I think, a lengthy email communication right after the conclusion of the first hearing, or adjournment, I should say, and then a more recent letter dated October the 20th, outlining some of those issues.
Yes, Your Honor. The initial email that I wrote to you following our last hearing dealt with your request to clarify the nature of the injunctive relief that was still outstanding. So that's the purpose of that. And our position on that has changed since that email in only one regard, and that has to do with the NDAs.
I'm sorry, I'm having a hard time hearing him. Can he speak directly into the mic, please?
Yeah, Yuli, my suggestion, Mr. Merchant, is either go to the podium or sit down and talk into the microphone, because those are the only ways to be heard.
Is this better?
Yes, thank you.
So yeah, following that email, Your Honor, the injunctive relief we requested in connection with the NDAs itself is exactly what they did following my email to you. In response, they apparently obtained another 100 or so NDAs and produced those to us. So those are reflected in Plaintiff's Exhibit 27, which was filed last week. So other than that, though, they have not provided any additional documents. So all of the other requests for injunctive relief still remain pending. They have told us that there are no additional NDAs. So for all practical purposes, the court does not need to enter injunctive relief on that particular issue because we are being told there is nothing else to do on that front.
Okay.
With regard to a separate issue, Your Honor, which is we've been handed just this moment, literally minutes before Your Honor took the bench, a motion for directed judgment, sanctions, and opposition to plaintiff's request for attorney's fees, which has been signed by Ms. Alabi as legal counsel at the Office of the District Attorney.
I assume that would be on behalf of the individual witnesses who were subpoenaed but ended up not being called to testify.
That's what we're asking Your Honor to clarify.
Okay. Well, I've never seen it before. It's not part of the record. And I'll note that it would be surprising to me if it was just handed to you in the last 5 to 10 minutes since I was running 30 minutes behind. But anyway, I haven't seen it, so I can't really address it.
Yeah, Your Honor. I can't address it either because I have to read through this, but essentially it appears to be more in line of a political document outlining Ms. Willis's personal position with regard to certain issues and actually asking for sanctions against us for bringing this lawsuit in the first instance. But I have not had a chance to read it at length or in detail. I point the issue out because I think we probably need some clarity as to who represents who in exactly what capacity before we proceed.
Is Ms. Alabi here? Oh, hi there. I didn't see you behind Mr. Bowman. Thank you. Again, this is not a document that I'm familiar with. It's certainly not a document that I'm going to address the merits of today because I don't have any record, hang on, of its having been filed. And looking at my docket, the most recent filing was on October the 18th. Now, it may be that it's been filed and just hasn't been accepted by the clerk. But in either event, substantively, we wouldn't be in a position to address it. But I think Mr. Merchant's point about, because we had to do this a little bit at the first hearing to clarify your role here, distinct from the role of Mr. Bowman and Ms. Monroe, who work for the county attorney and who are here representing the county entities. I understood your role to be at that hearing and now, and please clarify if I'm wrong, to be essentially inside counsel at the district attorney's office concerned with the subpoenas and demands for information that had been made to the individual employees, which might also, of course, include Ms. Willis individually. Is that roughly accurate of your role here?
And I just want to make sure that I'm correct in what the court just.
Well, here's what I'm trying to distinguish. You're not here suddenly supplanting Ms. Monroe and Mr. Bowman and saying that you represent the named defendants in this party. Is that correct?
I'm not supplanting anyone.
Okay.
I represent the individuals.
Can she get on a microphone for me, please?
Yep, come on up.
Trying to use my outside voice, but it's not outside enough. I apologize, Madam Court Reporter. Certainly representing the individuals that work within our office that were named in this controversy. However, this particular motion for directed judgment, sanctions, and opposition to plaintiff's request for attorney's fees is being filed on behalf of the district attorney's office and Fani Willis, district attorney in her official capacity. We've had some changes in strategy recently. This motion was supposed to be a joint filing, but that is no longer the case, but we do want to proceed with the motion.
Okay. Help me understand what authority you have to represent those two entities when I am looking at their legal counsel right here, who apparently have not joined in your motion.
I understand, Your Honor. The plan was for us to join into this motion. It was not until this afternoon that the district attorney's office knew that the county attorney was not going to be joining in that motion. So we are in a position where this was the strategy. This was the game plan. This is how we plan to proceed. And as such, we do plan to proceed. We in the district attorney's office plan to proceed that way because that's what justice mandates in this matter.
Okay, I understand all that, but you didn't actually answer my question, which is what authority do you have to appear here on behalf of the district attorney, Fani Willis, in her official capacity, and the Fulton County District Attorney's Office, who continues to be a party to this action, as opposed to the Ms. Monroe and Mr. Bowman?
Understand. I have my marching orders from my elected official who has instructed me to proceed in this manner just because it was not even within the last 2 hours that we were notified that this filing would not be joint. And so because of that, we are going to proceed as we have strategized to proceed, if we have planned to proceed legally. Judge, I'm not sure what authority we would proceed on, but we have talked to the county attorney. We are in alignment with what our arguments are and things of that nature. But the title and the style of this motion is as such because of what I just explained to the court.
Okay. So regardless of whether it was intended to be a joint motion or, and then subsequently it was determined that it was going to be unilaterally filed by you on behalf of Ms. Willis in her official capacity and the district attorney's office, such as it's constituted that she is the officer of, the primary officer of. What that implies to me, which I do find a little bit problematic, is that there's been a significant amount of time in which this document could have been filed. The court could have been made aware of it with the understanding that if a hearing was set today, this hearing has been set at least for 2 weeks, probably longer than that. And there was lots of notice to lots of people. So I don't exactly, exactly know how to address even a document that I don't have. If somebody could maybe email it to me.
Judge, I have a copy for the court. I will say it has been e-filed. It does not, based on what you've said, it does not appear that it's made its way to the record.
When was it e-filed?
It was e-filed today.
Right.
Yes, Your Honor. May I approach?
Yes, please. Have you provided a copy to opposing counsel? Okay. Okay. So, now that I actually have the document in my hand, which I'll note for the record is sizable. I don't know how long the actual motion is, but it's attachments, et cetera. I mean, it's easily several hundred pages, maybe 150 pages is my best guess. Again, was filed. It has not yet been accepted, but it was filed today based on Ms. Alavi's representation. I still don't know that I have an answer to your ability to even appear on behalf. I've just never had this issue. Is the district attorney's office firing the county attorney and proceeding with you? And if they are, do you even have the authority to appear in this manner? I don't know I'm not questioning your authority. I'm telling you, I don't know the answer to that question.
I understand, Your Honor. And I will say that there's been no discussions that I've been aware of about firing the county attorney. It's only been discussions about filing this particular motion. Most recently, of course, we talked about, other matters that have come up during the pendency of this litigation. And to the court's comment, the motion itself is 14 pages. The rest of the documents are exhibits.
Thank you.
So, yeah.
Okay. So where we left off, as I was sort of reciting, the procedural posture of the case is certainly when the evidence is closed, right? The party, from the moving parties, from the plaintiff's perspective, the defendant certainly has the right to move for some sort of directed verdict or directed judgment. So that's, I guess, fine. But to the extent that there's some effort to, I guess my point is, if y'all want to move for directed verdicts on these claims at the appropriate procedural time, right, which would be when the evidence is closed on the plaintiff's side, then we can certainly take that up and address that. That would be procedurally appropriate. To the extent that the court were to rule in favor of the defendants in the case, right, to grant some sort of directed verdict, then of course, under all the civil procedural rules that I'm aware of, you would have as much as 45 days from then to assert some sort of basis for sanctions under 915.14 or anything else, right? So it feels like the motion is premature in the sense that if we close the evidence today, y'all can move for your directed verdict, and I'll hear from somebody on behalf of the district attorney's office and Madam DA on a motion for a directed judgment or directed verdict. And then if there's an issue of sanctions to address, then we would address it at that time. And at that point, your motion would be perfected, right? And then there would be an opportunity for the plaintiffs to respond. Is that acceptable in terms of how we're going to go on the procedural part?
Judge, we're at the court's pleasure. We wanted to get the motion filed. We are back here today. This was our first opportunity to be before the court. So we wanted the court, counsel, everyone to have our position with regard to.
But not really, not with the filing, right? You've had plenty of time to file this document. I understand that it takes a while to get documents together, especially with lots of exhibits. Totally understand that. But this is, you've had some time to file this document.
Judge, I would disagree with that. There have been some things that have happened, and we have outlined them in the motion that have taken place during the pendency of this case.
Which was just filed today, and
Yes.
I haven't had a chance to consider any of the whatever behavior or actions that have been taken that you find problematic. So.
Yeah, so there have been some kind of recent developments that we wanted to outline for the court. We wanted to make sure that the court was aware of it. That supports our position to rule in defendant's favor and to enact sanctions and all of those things. And so if the court wants us to hold on argument, we're happy to do that. I just wanted, kind of as an aside clarification, the court said that the sequestration issue is now over. So does that mean that the witnesses that were subpoenaed on behalf of the district attorney's office are released from their subpoena?
My understanding was that they were released from their subpoena at the conclusion of the last hearing, because the plaintiff's announcement on the record was that they were resting as to their evidence that they intended to offer to demonstrate that the Open Records Act wasn't complied with, and they were reserving only their opportunity to put evidence on as to their alleged damages. Did I accurately reflect what your position was at the time, Mr. Merchant?
Absolutely.
Okay. And so that's why I was just making sure that we didn't expect to hear from any of those witnesses, and to make sure that that issue was fully put to bed. Because as I said, my understanding was they were all released back on, and I should know the day of that, and I don't off the top of my head, the last hearing that we had.
Understood, Your Honor.
So for purposes of the remainder of this hearing, for the remainder of what the plaintiffs intend to put on, am I going to hear from you, or am I going to hear from Mr. Bowman and Ms. Monroe?
You'll hear from Mr. Bowman or Ms. Monroe.
Okay. Thank you.
Thank you, Judge.
Anything from the county attorney's office regarding the resumption of the evidentiary portion of this case in terms of the merchants calling witnesses as to their alleged damages?
So I just wanted to clarify as to where we last left off. There was one last thing that the plaintiff had agreed to remove Fulton County, Georgia, as a defendant to this action.
Yes, they were, and I had asked them to await my ruling, because there was a motion to dismiss pending substantively that I had denied. And then subsequently, I had verbally denied it. The parties agreed to dismiss Fulton County after that. And I asked that y'all wait until I get my order on file, which now has been on file for some time.
Which they have, and
okay.
then a proposed order was submitted to a motion, and proposed order was submitted to the court.
Okay.
I don't recall if the court has signed the order. If you did, then I just wanted the record to reflect that.
Right. So I'm looking at the docket, and the docket number 93 indicates that an order of dismissal with prejudice of Fulton County, Georgia was entered on October the 2nd.
Perfect. Just wanted the record to reflect that.
Okay. Okay. So that means that the remaining parties in this case are the Fulton County District Attorney's Office, to the extent that it is an agency subject to the Open Records Act, which is what my ruling is currently, and District Attorney Fani Willis in her official capacity as the District Attorney of Fulton County. Okay. With that, the plaintiffs may call their next witness.
And Your Honor, just as a point of clarification.
Yes.
We did reserve our right.
I'm sorry, Mr. Merchant, can you please get on the mic? Thank you.
We did expressly reserve the right to call witnesses related to damages, but
Yes, sir.
my understanding was that the court wanted to perhaps hear whether the defendants had any evidence on the issue of liability first.
Okay.
We're happy to proceed with the issue of damages because I think it's probably right now. The letter I sent to Your Honor yesterday outlines substantial justification and what that means under our law. So if Your Honor is comfortable with that, I don't need to proceed with argument. We can just move right into the issue of damages.
Okay. Ms. Monroe, was the county intending to call any witnesses on the issue of demonstrating that the Open Records Act was not complied with in this instance by the two remaining defendants?
Just 1 second.
Sure.
And Your Honor, I think I found the source of the problem. Can you hear me now? The mic's actually on, so that's helpful.
Yes, I can. Thank you.
And Your Honor, we were going to, our plan was to call Ms. Merchant for just a brief bit of questioning on that issue.
Okay, so the defendants have called Ms. Merchant. If you'll come up to the witness stand. You will raise your right hand, please. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You may be seated. Please keep your chair away from that ledge. It's a rolly chair, so.
Keep it, is it good
Like,
work?
roll up to the microphone and make sure that you speak loudly and clearly into the microphone. And if you will state and spell your name for the court reporter.
Ashley Merchant. My first name is ASHLEIGH. My last name is Merchant, MERCHANT.
Go ahead.
Thank you, Your Honor. Good afternoon, Ms. Merchant. How are you?
Oh, I'm good. How are you?
Good. And to clarify, you are plaintiff or one of the plaintiffs in this case, is that correct?
Yes.
Okay. And this case was filed on January 30th, 2024, correct?
I'd have to defer to my husband on that. That sounds about right. January.
Okay.
I know it's late January.
Okay. But if it's in the record of January 30th, you wouldn't argue with that?
I have no reason to dispute that.
Okay. And since we were last together at the hearing a few weeks ago, have you received any additional documentation regarding any of the requests at issue here?
Yes, we received some more NDAs.
Okay. And with respect to those NDAs that you've now received, do you believe that new documentation concludes that particular request regarding the NDA?
No, I don't.
Okay. And what is the basis of your belief that is not complete?
Yeah, so I've talked with several people who were employed by the district attorney's office that have signed NDAs. People have reached out to me, prior investigators, prior lawyers have reached out to me and said that they signed an NDA and they wanted to talk to me about certain things, but that they had signed NDAs and they wanted to take a look at the NDAs to see if they could talk to me. And I didn't have their NDAs. They weren't part of the group that you gave me. So, and those witnesses didn't have copies either. They said those were copies that had been left at the DA's office. So I know 4 or 5 people I've talked to had signed NDAs and I don't have those. So that's why I believe I didn't get all the NDAs.
Okay. And were those people current or former employees of the district attorney?
Former. I think they were all former.
Okay. And did they relate to you that those NDAs were signed during the time period encapsulated by that request?
Yes. And some of them had actually reached out to me, which is why I originally requested it. So a witness would reach out to me and say, hey, I really want to talk to you about something that went on, but I'm worried about this NDA. I don't know what the punishment is for the NDA. And so that's why I first knew about the NDAs. You know, a witness would say, I really want to chat with you, but I don't know if I can be sued under these NDAs. And I didn't know what was in the NDA. And I told him, obviously, I can't give you legal advice, but I should at least be able to see the NDA because I believe, based on the one that I had from Mr. Wade, that the only punishment was that they would be fired if they spoke with anybody. But, you know, that's why I originally asked for the NDAs. I was surprised that a public agency had required something like that to be signed.
Okay. So previously we've discussed just generally open records requests made by you or your office to the county. Would you say that you frequently make open records requests to either the county or the district attorney's office?
No, I actually would not say I frequently did. I was surprised Mr. Bonds testified that I had made 40 something. I've made, I believe it's 10 to the district attorney. I mean, total maybe, I don't know, less than 20 in total to Fulton County entirely. All of the different entities. I made, I believe, 10 to the DAs, right around 10. A couple of the ones that I made to other groups, like I made a request just, for example, to IT or purchasing, and then Dexter Bond went in and closed it out from the DA's office. So I actually didn't make an open records request to the DA's office, but somehow in your portal, he went in and was able to close it out. And so the open records request in the portal would show closed, and it would have a letter from Dexter Bond attached to it saying closed, see this letter, which I hadn't even made the request to the DA.
And so of those approximately 10 requests that you've made, what's the time frame over which you've made those requests? Do you know?
A year.
So in the last year. Okay. Now, when you make those requests in the past, have you ever had occasion to need to follow up because you felt like you didn't get what you were looking for?
Yes.
Was that only with the DA's office or other entities?
It was primarily with the DA's office.
Okay. And when you've done that in the past, have you ever, how have you handled that previously?
So out of the open records request, I think the easiest thing is to sort of classify ones that related to criminal cases that were pending, and then ones that didn't. The ones that are subject to this lawsuit really are ones that relate to no criminal case. I had a criminal case that I was doing open records where I was seeking invoices and contracts for an independent contractor who was working on that particular case. So I did a series of open records requests to try and find the contracts that were the contractual authority for that person to be hired, how that person was paid, whether or not they had an oath of office, things like that. So those were things I was investigating in regards to that criminal case. Most of those requests were, some were partially filled, let's put it that way, but they were not completely filled. I did have a hearing in that criminal case, and I was able to use my subpoena power to get records in that case. That is why those records were not subject to this lawsuit ultimately. They might have been initially subject to this lawsuit, but ultimately they were not something that was sought because I was able to get those through subpoena. The issue is I can only subpoena things that are relevant to a hearing that I have and the issues in that hearing. So I did open records. Let me just kind of back up. I did open records, and then I got a hearing. When I got that hearing, I was able to issue subpoenas for those same things that I had been denied in open records. I was able to get them because I could issue a subpoena in that hearing. I could not, however, issue a subpoena for things that weren't relevant to that hearing, which is why this open records lawsuit has continued.
What would you say that those things that have been requested pursuant to the requests in this lawsuit are related to the ones in the other criminal case as well?
No,
They're not in the same line of inquiry?
no. Some of them are, but not all of them, no.
Okay.
Like NDAs they don't have any relation to that case. Trying to think all of mine. The NDAs didn't have any relation to that. Forfeiture funds. The forfeiture funds had some relation, but it went a lot deeper than that. The rebranding didn't have anything to do with it, no.
Okay. Now, when you make open records requests, how do you, from a practical standpoint, how do you do that? Are you using the portal from the DA's website, from the county's website? Does it depend on who you're making the request to?
Yeah, no, so it depended on the time. I would go to the entity. So I would go to the DA's office and I would use their landing page, and I assumed that IT could track how I was doing it. So I was always very careful to make sure that I did it the proper channels. So I would go to the IT department. I'd go to the DA's office, and there was a link on theirs that when you clicked on that for open records, it would take it to the county open records portal. That link was not always active. So there was a time period where I was able to go to the DA's office and file open records request. And then after we filed this lawsuit, for a period of time, that link disappeared. So I wasn't actually able to make any open records requests to the DA's office during that period of time. It is now back, but I have not since made any since it's back. But I would go to the landing page of the DA's office, click on the open records link for records. It would take me to the county portal, and then I have a login, and I would type in what my open records request was.
Okay. Now, in the past, when you've had issues getting what you felt were a full set of responsive documents, have you ever had to go further than just following up with the department before?
Yes,
And what did you do in that situation?
I filed a complaint with the Attorney General's office.
Okay. Did you do that in this case?
Yes. Well, I did it. So I'm actually not sure. When you say this case, there's so many different requests that, I mean, I had about 10 requests and some of them were partially filled, some weren't. I filed a complaint with the Attorney General. I definitely did that. I don't know which request it would have been listed under, but I know that I did do that.
Okay, do you know, so you don't know if, and let me go back to sort of reset a little bit. Which particular request do you believe still have outstanding documents in this case? Is it all of the ones that you filed on, or is it limited to a couple of those requests?
If I could look at the actual request, I can tell you exactly. Is that okay? I mean, I have them. I'm happy to look at them. Okay.
Yeah,
May I go?
Yes.
And would it be easier for you if I mentioned a couple that, based on what's been testified to, and the proceedings in this case that I think we're still dealing with?
Yeah, that's fine. I'm looking at our letter, just so you know, the January 24th letter, it just sort of summarized the request. So I was just looking at that to sort of orient myself. But if you want to ask me about a specific request, I'm happy to answer about that.
Okay, so if I'm not mistaken, I believe the ones that we still have at issue, and based on your testimony earlier, saying that the NDAs
Yes.
were not still complete. We're looking at, there were two requests regarding critical mention, which are R00272, 010924, and 675011824.
Yes.
Do you believe those are still outstanding? Or have any documents that are still outstanding?
I believe that they were not completely complied with, but for the purposes of this litigation, we were not going to be proceeding with those anymore because we didn't have any way to prove that they haven't been complied with fully.
Okay, so for purposes here, we're done with those in terms of production.
Yeah, I understand what you're talking about. Yeah, so these documents, you asked me my belief. I do not believe that we have received all the critical mention documents. The county spent $20,000 on a contract for this. I do not believe that it received 2 PDF graphs in exchange for $20,000 and 24 months of a contract for critical mention media monitoring. I have no way of proving that, but I find that hard to believe personally, that that's what they got for that money. Because I can't prove that these reports exist, we are not proceeding with anything further in that regard, if that makes sense.
I believe so, yes, thank you. And then we mentioned that the NDAs, which were R000305.
Yes, so the NDAs, I've received, I believe, 122 to date. I know that there are more that we have not received. And based on that, I'm sure there's more, but do I know if there's more?
And you described having some conversations with former employees. Is there anything else that leads you to that belief, or is it just based on those conversations?
Well, the first thing that led me to that belief was the fact that the first issue I had was, so Dexter Bond, the open records custodian, had done a business record certificate in a civil case where he certified Nathan Wade's NDA. Then he did a business record certificate in our case where he certified that there were no NDAs. So I had 2 certifications where he swore to 2 completely different things. Based on that, I do not have any faith that they actually have been searched for.
And then the last one that I think may still be at issue, I want to be clear, is the list of attorneys that have been hired during Madam DA Willis's tenure.
Yes.
And that was request 000198 010824. Is that
Yes.
that one still?
That is still outstanding, yes.
Okay. And so with respect to these still outstanding requests, did you send these requests to the district attorney's office or to the county? Do you recall?
I can tell you. Let's see. I'll tell you exactly who I sent them to. The personnel records, the list with the dates of hiring, that was sent through the public records portal, but the department I was requesting records from, there's a drop-down box when you go online, and the drop-down box I did was district attorney. So I've got that for that one. And then let's see, I can tell you the next one. Well, critical mention, I don't think you asked me about that. I also did, I did it to human resources. I did one to human resources. Let's see. So the one that I did regarding promotional material, I submitted that request to purchasing. So that's one of the ones I'm glad you asked me about it. That's actually a good example. So I submitted that request to purchasing, but somehow it got hijacked by the DA's office, and the DA's office closed it out with a letter from Dexter Bond. So I actually submitted that request to purchasing, but the DA's office responded. And I'm guessing it's because I asked for records in there from the DA's office. But I did not submit that to the DA's office. I submitted that to purchasing.
And do you know if any of these were ones that you submitted to the Attorney General's office for a complaint?
I don't. That wasn't part of this litigation, so I didn't really pay that much attention to it. I can tell you that. I can find it. The one that I submitted, there was only one, and I don't know which one it was.
And maybe a better question might be, how did you make a determination regarding what requests to send to the Attorney General's office versus what requests to go to litigation more directly on?
It depended on the time frame mostly. So, and also the AG didn't really work. I mean, I've done open records for many years. John and I have both done open records. We've gotten, I mean, it's something lawyers do. Every lawyer needs to know how to do open records. And normally if an agency was not responding appropriately, I could file a complaint with the Attorney General, and they would call and say, hey, follow the law, and it would be resolved pretty quickly. That was by far my preferred option because I certainly don't want to spend the time or money having to litigate. I tried that early on in this case, and it didn't help. So I didn't need to beat my head against the wall.
Yeah, but there were still some that you did not go to the Attorney General's office about. You just went straight to litigation after having some discussions with the department themselves.
I only filed a complaint once with the Attorney General, and I think it was a generalized, hey, Fulton County's not paying attention to open records requests. Please help. And they did not.
Okay. Now, with respect to the requests you sent to the DA's office, did you ever speak to or have any correspondence with Madam DA Willis herself regarding this?
No.
Do you have any reason to believe or any evidence that Madam DA was involved in the actual response to the open records request that you submitted?
Oh, she's copied on emails. I mean, there's emails that she's copied on, and then she received, she received the lawsuit. She received the letter about the open records. I mean, did I personally speak with her? No.
Okay, and did you ever see her actively take any involvement in response to the open records? Did she say, hey, I'm trying to pull this, but she never, or did she ever correspond with you at all?
No, she did not.
Okay, all right. So, considering that Madam DA did not take in any part that you were aware of in terms of actively responding to the request, can you shed a little light on why she was named as a defendant in this action, either in her individual or official capacity?
She's the elected DA. It's her office.
Okay, and then with respect to her as the elected DA, do you believe her to be the person responsible in the department for complying with open record, to providing responses to Open Records Act requests?
I think that every government agency has a duty to respond to open records requests. I think when you have an elected official, that they're the ones that are actually held accountable by the public. And so they are the one that sets the policy.
Are you familiar with the custodian of records for the district attorney's office?
I have since in this litigation learned that I guess it's Dexter Bond now.
And is there a reason that during this litigation, when you learned that it was Mr. Bond who was the custodian records, that the amended complaints continued to name Madam DA herself?
Because she's the DA, he's not. I mean, he could be fired and not there tomorrow. She designates him as the open records custodian. That's her job. He's just an employee. Like, she's allowed to designate whoever she wants, but that can change at any given time. I mean, county employees can come and go.
When you have an identified custodian of records, is there a reason why you would choose a different person than that to name as the respondent?
No, but that would be something that John would do anyway. I mean, he's the one that does the civil litigation, not me.
And if I could just interject here, right? The Fulton County District Attorney's Office was the original defendant, and the county took the position that that was not an entity capable of being sued.
That's right.
And then affirmatively stated that, I guess, if they're subject to the Open Records Act, it would be the district attorney in her official capacity. And I've already dismissed the district attorney in her individual capacity, although I understand the reason that it was named in that manner was a belt and suspenders sort of approach. But I don't know that asking Ms. Merchant why she named the Fulton County District Attorney in her official capacity really advances the ball, because they did so at essentially my urging based on the county and the district attorney's office's position that that was not an entity capable of being sued. So,
Okay, I'll move on with my question. It's on your own. Thank you. All right, Ms. Merchant, you were here and heard Mr. Bond's testimony and
I did.
examined him.
Yes.
So during his testimony, there was quite a bit of discussion regarding the critical mention documentation. Just want to confirm with you that you made the second critical mention open records request because you felt the response to the first request was not complete. Is that right?
Yes.
Okay. And do you recall what you believe was missing at that point in time and why?
Yes.
What was that?
So the first one was what I would call a compilation of documents. It was 44 pages. It was clearly cut and pasted. Someone had removed dates, times, parties, subject matter, things like that. So someone had to actively take those documents and redact them. And I mean, from the cutouts, it looked like they literally cut and pasted them. There were things that were not part of it. I mean, you would see, part of an email and then you'd have no to, from, no date, nothing like that. And then you'd have another part, and then you'd have a link that didn't actually have a hyperlink. So I could tell that the whole emails were not contained. I could tell that there were significant parts of the emails that were missing. I also could see on the subject matter, when you have an email, there's a subject matter, and below it, if you have an attachment, you see a list for an attachment where there would be a JPEG, a PNG, a TIFF file, a PDF, something like that. There's a link. Well, when I received those documents, I saw the name of the link, the name of the PDF, or the name of the JPEG, whatever that was. One time it was a PowerPoint. I saw that as an attachment, but that attachment wasn't provided. So someone had printed off a document that clearly showed there was an attachment, but they had not given me the attachment. So I thought I was super clear when I wrote back and said, hey, I want the attachments to these documents. And I tried as hard as I could to highlight exactly where they were, named the document, named where the attachment was, named what the attachment, actually was called, so that whoever printed those emails out could go and actually click on the attachment and give me the copy of the attachment.
Okay. Now, being that you believe that there was some missing documentation, did you include all of the missing documentation you believe existed? Was that in your follow-up request?
Yes.
All of that was in your follow-up request?
My follow-up request was very specific as to the documents that were missing, the PowerPoint. I mean, yes.
Okay, in that second request, I can just read a portion of that for you.
Which request number is it so I can follow along?
Yes, R000272 010924.
Okay.
And it said, I asked for the analytics and documents that are clearly referenced. And I'll skip a little bit saying, in monitoring the reports with analytics provided to the DA's office monthly, appears the emails may have been accessed on a regular basis may all have access to these on a regular basis. It names a number of individuals, and those are public and paid for. Does that encompass all of those items that you just listed off?
So I'm looking at a different one than you are. I'm looking, you had said 010924. In that one, I say, I'm seeking a copy of any and all correspondence, and I put including copies of all contracts and or payments and all analytics and or reports to and or from. So yeah, I mean, I think analytics and reports are clear. And then contracts and payments are clear. So that's that case number. But then I also followed up with another one. And this one I was even more clear. I referenced the prior one. I said, I got a set of emails. And then I said, I asked for the analytics and documents that are clearly referenced and attached to those emails. I put that reports with analytics were provided. It appears the emails, and I put the names that I could find from those: Jeff DeSantis, Fani Willis, Jeremy Murray, Pallavi Perkasta, Ryan Bryant, and Rita Kepler. And that the reports, yeah, that they're public documents. Thought that was pretty clear.
All right. All right, we'll move on a little bit here to the subpoenas that were issued during the course of this litigation.
Yes.
Were those all sent to employees of the district attorney's office, or were they sent to people from different entities as well?
There were multiple different places that I sent them. So I had subpoenas to third-party vendors. I subpoenaed Critical Mention, which, for example, had I not subpoenaed them, I would have never known about, because I still haven't to this day received copies of the payments for the second year of the contract. Critical Mention was a 2-year contract. The first 12 months was paid through purchasing. So I received the county documents from purchasing about that, showing I had the contract and I had the actual payment. The second year I asked and asked and asked, and I've never received it once from the county, still to this day. I received it from Critical Mention. So I did that.
Were there others besides Critical Mention, individuals that were employed in other agencies or other certain, at least, departments of the county?
Yes, there were other departments of the county. So I sent them to Critical Mention. I sent to IT. I sent to, I think one of the ladies used to work for Fani Willis, and now she works for a different department. I sent it to them too.
So when you're subpoenaing individuals who do not work for the district attorney with respect to documents that you believe are in the possession of the district attorney's office, how are those individuals supposed to know if the district attorney has those items? And do you believe, I guess let me start with that question first.
Which question?
How do you believe, or why do you believe that those individuals who are not a part of the district attorney's office would have access to or possession of requested documentation that you requested from the district attorney's office?
Well, they did actually have it. That's how I got most of it. So I don't know how. So that's the problem.
They had possession of district attorney materials?
Yeah, IT did. That's where I got all the emails from. So IT apparently did. And you have to understand, when I don't work for Fulton County. So when I do an open records request, I don't know how their systems work. I don't know how things are stored. I don't know things like that. So I know that there are documents. I know that there is for example, there is a PowerPoint attached to an email that has its only DA employees on that email. I know that PowerPoint exists. Do I know how the county stores it? No. And I have learned that I have to ask for it every different way I can possibly ask for it in order to avoid someone saying no records exist. So I asked for it from the DA's office. They did not give it to me. I asked for it from IT. IT all of a sudden is able to access all of those. So apparently IT can go into the DA's emails. I did not know that, but I'm glad I subpoenaed them because I learned it.
Did you believe any of the individuals who do not work for the DA's office, at this point we'll say other than IT because you've explained that, but any of the individuals who don't work for the DA could produce documents on behalf of the district attorney responsive to your request?
I don't know. You'd have to ask me. You'd have to be more specific who you're talking about.
Was there anybody that you subpoenaed that you believe could produce documents on behalf of the district attorney's office other than individuals who work for the district attorney's office? Okay,
I think I understand what you're asking. So I didn't care if they were produced on behalf of the district attorney's office. I just wanted the documents. So when I've just, for example, subpoenaed ITs, obviously they're not producing them on behalf of the DA. They're producing them on behalf of IT. I really don't care who produces them. I just wanted the documents. So yeah, Critical Mention supplied documents. They were not supplied on behalf of the DA, but they were DA documents.
that just because somebody who has dealt with the DA's office has documents, that those documents are also held or belong to the district attorney's office?
I'm sorry, I don't understand what you're asking me.
If critical mention is producing documents, how can you be sure that those documents are also in the possession of the district attorney's office?
Because the law requires that the district attorney comply with the Records Retention Act. And so, for example, to answer your question, critical mention was paid with a check out of the district attorney's fund. It says the check says DA Willis for Fulton County. The law requires the DA's office maintain copies of all of that. And so I would assume that when I asked for that document, since the law requires that they maintain that document, that they would provide it to me.
Have you filed, in this case, are there any claims in this case regarding record retention, or is it just open records?
So an Open Records Act litigation is not going to involve a violation of the Records Retention Act. But when I'm asking for a document in open records, one of the things that I want to know is, does the document exist? Does it have to exist? Because I've learned one of the answers that I get, particularly from the DA's office in Fulton County, is no responsive records. So I have to go look at the records retention because they say no responsive records. Well, they've taken a position that we don't maintain any records essentially, so we don't have to give you anything. But the law actually does say that they have to maintain certain records. So I go and look at that. I'm not going to ask for something that I don't know that they're required to keep.
Is that a position that they've taken that's been taken in this case, that the district attorney isn't required to? I'll withdraw that question. But based on the response, I want to go back a little bit to your understanding of, do you agree that the DA's office and the county themselves are separate entities?
Yes.
Okay. And so even if a different department has documentation, that doesn't mean that the district attorney's office necessarily has that documentation. Would you agree with that?
Depending on the documentation, yes.
Yeah. And so even if the people who you subpoenaed in this case that work for other departments had that documentation, it doesn't necessarily mean that the district attorney's office has that documentation.
In this case, it did, because when I subpoenaed those entities from the district attorney, I also received the same set of documents. So clearly they did have it.
Okay. Now, with respect to how the case came about, you had mentioned you didn't go to the DA's office, or excuse me, to the Attorney General's office this time, like you did on a different issue. Could you explain again why that would have been the case? Why you didn't attempt to pursue the Attorney General's office route again? So
we have different remedies when the Open Records Act is not being complied with. One of them is to file a complaint with the Attorney General. There are some agencies that the Attorney General is very quick to call and help with. In fact, I think the first time I met you, I filed a complaint with the Attorney General in East Point because they were not providing any documents. The Attorney General called you, you were the city attorney at the time, and you said, oh my gosh, you're right, and I got the documents. I've learned that municipal courts respond very quickly to the Attorney General. I've learned that the Fulton County DA's office does not really care when they get a call from the Attorney General. So I could have wasted time and sent requests over and over to the Attorney General in this case, but that would have just been a waste of time.
Okay. And in your consideration, did the fact that the Attorney General also is not quite as high profile or high publicity as something like filing a lawsuit against the district attorney's office?
Your Honor, objection. Not sure what the purpose of that question is, other than to make a political point.
Sustained. You can try again or rephrase.
Thank you, Your Honor. We discussed previously that you had made some other open records requests, and there were subpoenas involved with another case that you're handling, a fairly high-profile criminal matter involving prosecution by the district attorney's office. Was it your intent to include some of these documents in that litigation as well, if they showed what you wanted or what you thought they might?
Yeah, well, I think the only way to answer that question is to look at the timeline. So I did a series of open records requests in September of 2023. It's fair to say that most of those were related to that criminal litigation. At the same time, though, I actually, I became the president of the Georgia Association of Criminal Defense Lawyers in January. We were actually working with some other public interest organizations prior to my taking over as president. We were doing some investigation on the jail conditions and on the backlog funding for the jail. Most of the records that are subject to this lawsuit actually had to do with the public interest work I was doing on tracking funding for backlog and the jail issues. So there were two separate real umbrellas, that I was working under. I was looking for things in regards to the criminal case, but I was also looking for things that had absolutely nothing to do with the criminal case.
Mr. Bowman, can I ask a question? Your line of questioning right now seems to be going towards the intent that the plaintiffs had in seeking the records, or the use to which they intended to put those records. And I'm not aware of that being a relevant factor for the court's consideration. If that is, then please tell me why I should be considering that. But my understanding is essentially, is it a public record? And was it properly requested in a way that was understandable and could have been complied with?
And Your Honor, I think maybe this goes more towards less the actual production of the documents and more towards the attorney's fees issue. So I will withdraw. I'll hold off on some of these questions until we get to the attorney's fees portion.
Thank you. I appreciate that, Mr. Bowman.
All right. If you give me just a minute, Your Honor, let me make sure that that's exhausted my questions on the substantive portion. Okay. A couple points that I would like to go back to regarding the documentation that you did end up receiving from IT related to emails. Mm-hmm. Because you've named the district attorney's office and the district attorney's office is who's still at issue in this case. If they did not have those documents, you said you received them from IT, correct?
I received them from you. So you all, actually Ms. Monroe, I received them from Ms. Monroe. They did not send them to me directly. Ms. Monroe sent them to me. She sent them to me from IT, Fani Willis, Dexter Bond, Kevin Armstrong. I'm trying to remember everybody. There were 4 or 5 different people. She sent them to me as the certified records in response to our subpoenas for all of those folks. And there was someone else, maybe Jeremy Murray.
And was that certification of those records, did you know, did that come from the district attorney's office or from the IT department?
It came from, so whoever, Ms. Monroe, it came from Ms. Monroe, but she sent it, like, if it was the IT packet, it came from IT, like whoever was in charge of IT certified that. They did the business record certificate.
And being that if IT is the entity that provided those documents, would you agree that that's not relevant to what the DA had in their office if they are documents that the IT department has?
Well, they're the same documents that you provided me from the DA's office also. So you provided them to me from Fani Willis, Dexter Bond, Kevin Armstrong, all of those people. So I basically, it was like 197 pages and I got the exact same set of documents. I don't know where you all got them from. You could have gotten them from IT. You could have gotten them from the DA. I have no idea where you got them from, but the same set was certified from each different agency or each different person, but it was one set of documents. I have no idea where you guys got them from.
All right, and Your Honor, could we have just a moment?
Sure.
All right, thank you. one or two more follow-ups. I apologize. With respect to the NDAs you believe are still outstanding and the individuals you spoke with, do you know, or could you provide the names of those individuals or the individuals that you believe have NDAs that are still outstanding? And if you can't recite it now, to be able to provide it to us.
I'm, like I told you before, I'm happy to provide it to you, but the witnesses that told me that don't want the district attorney to know who they are. So, I mean, if the court wants me to provide it, that's fine. I'm not hiding it at all, but those people have asked me not to. They don't want the district attorney to know that, so.
I guess at this point, though, we would ask for them because if they're at issue in the case, we would need to know who they are so that we can check if those documents actually exist.
Right. And those are the people that have told me that they signed NDAs, which you all did not provide me the NDAs. So they're the only ones I know. But I mean, you provided 122 and there's a lot of DAs that aren't in there. So I don't know if they were pick and choose. I mean, who signs NDAs, who doesn't? I have no idea.
Right. Right, so just if we can have those, and then I think the rest of the questions I had, we'll save for the rest of for the attorney's fees portion.
So the names of those individuals, to my way of thinking, would be relevant to two issues. Number one is whether or not their NDAs have been provided for purposes of any injunctive relief that the plaintiffs are seeking. I don't think that their names need to be disclosed in open court for that purpose. The second reason that it might be relevant would be the extent to which there's any way to identify or understand if the fact that those four or five, persons' NDAs were not produced is somehow indicative of a failure to produce others that might be in the possession of the DA's office. I also am not sure, particularly given that they're former employees, if that would be relevant in open court either. But if you feel strongly, I could be persuaded, Mr. Bowman.
No, Your Honor, we're happy to take them off the record so that we're not putting people's names out in open court. That's fine. Just so we can confirm whether or not those documents do exist.
Okay, thank you.
I'm happy to provide them.
Thank you. With that, I believe that's all I have for this portion. We'll come back to a few more questions.
Okay, understanding that you're reserving your right to question her on other matters.
Yes, thank you, Your Honor.
Mr. Merchant, questions for this witness?
No further questions for this witness on this issue, Judge. While she's on the stand, though, if Your Honor's inclined, I can question her about damages now, or we can wait for Your Honor's ruling on the liability issues. But we don't have any additional evidence but for damages.
Okay. I think that just for efficiency's sake, it would just make the most sense to go ahead and have you question Ms. Merchant regarding the issue of damages and outstanding issues, if there's any injunctive relief other than the NDAs.
And yes, Your Honor, I think the issues with injunctive relief, to tackle that issue first, I think the ones that we set forth in the email to you, those are still the current issues.
Okay.
And framed in that manner as well. I'm not aware of anything else. Ms. Merchant has testified, obviously, to some things that she thinks probably are incomplete and has evidence of that. But as we sit here today, there's no way for us to tell you how to tell them to do it.
Okay.
Which I know puts you in a tough spot.
As an aside, the Supreme Court has said that one of its forthcoming opinions tomorrow will be the Gonzalez versus Miller case.
Of course. May I approach?
Yes, sir.
Ms. Merchant, I've handed you a copy of pre-marked plaintiff's exhibit number 24. Do you recognize it?
Yes, this is my record of time, description of work performed. It's a Word document that I kept with an outline of my time that I had to spend on this litigation.
Okay, is this a true and accurate copy of the time record that you prepared in the case?
Yes,
Are all the time entries listed on this document for the civil action case number 24 CV001325?
yes. and the open records that before the action number came about.
Okay, can you tell the court how you prepared this document?
Yeah, I just keep sort of keep track as I'm going. Keep an open like Word document. I really was trained. I used to do work for the 11th Circuit Court of Appeals as an appointed lawyer, and this is how they like them to be done. They like their times kept like this. I used to have a judge who appointed me fun cases, and so I'd had to learn how to keep my time for that. And so we keep them in increments, time increments, 0.10, a tenth of an hour increments, and so it's just tracking what I did on the case.
Okay, what is, before I ask you that, Your Honor, at this time, plaintiff would move into evidence plaintiff's exhibit number 24.
Mr. Bowman,
No objection, Your Honor.
exhibit 24 is admitted.
Ms. Merchant, can you tell the court the total number of fees and hours that you had in this case prior to today?
So this document is as of September 30th. I had 78 hours, 78.7 hours, and then attorney's fees. So attorney's fees, to be fair to the county, it definitely significantly reduced my normal average rate and looked more towards what the Attorney General pays for this type of litigation. And so my total attorney's fees as of September 30th were $23,610.
Okay, can you tell the court how you arrived at the $300 figure based on your review of the Attorney General's website?
Yes, so I went to the Attorney General's website. There's a couple entities that hire outside counsel to do work in civil cases, and one of them is the Attorney General. They publish every single year. They publish, they're very transparent with their rates that they pay lawyers, and they're very transparent with how much money these lawyers bill. So they actually publish it online. You don't even have to do an open records request. You can just go online and click it, and it shows it. And so I reviewed all of those, and lawyers that have been practicing approximately the same amount of time that I've been practicing, I used those rates.
How would your private rate for your services be different if you had not used the Attorney General's website?
It would be far higher than $300 an hour. I mean, I've been practicing 21 years and, do highly specialized work. I mean, I would charge at least $600 an hour.
Government approach?
Yes.
Sergeant, I'm showing you what I previously marked as plaintiff's exhibit 29. You recognize it?
Yes.
Mr. Merchant, I can't hear you.
He showed me what is marked as plaintiff's exhibit 29. It is an affidavit that I prepared that has a very brief outline of my my past work. And yeah, sorry.
Is it a true and accurate copy of the affidavit you yourself prepared?
Yes, it is.
Okay, Your Honor, at this time, plaintiff will move into evidence. Plaintiff's exhibit number 29.
29.
Yes.
Any objection?
No, Your Honor.
Exhibit 29 is admitted. And did you say it's like a CV or
Yeah.
okay, an affidavit? Thank you.
So, Ms. Merchant, can you explain to the court a little bit more about your experience as a lawyer?
Sure. So I went to the University of Florida, Levin College of Law. I graduated in 2003. I came to Atlanta and I worked at the Southern Center for Human Rights. I actually did some civil litigation with them, and I did death penalty defense work in Georgia and Alabama. Prior to coming to Atlanta, I worked for a criminal defense lawyer in Florida. And then when I moved to Atlanta, I worked at the Southern Center. When I was admitted to the bar here, I was sworn in June of 2004 in this courthouse. Judge Baxter swore me in, and I worked at the Metro Conflict Defender at the time. That was prior to the Indigent Defense Act. So the Metro Conflict Defender actually had the contract for state court work. So I was a public defender downstairs in state court here. And then I left that job to take a job at the Office of the Public Defender, which had the felony contract. So I moved to do felonies, and I was in the complex trial division at the public defender here when it was Vernon Pitts. And then I moved to the appellate division. And then I left that. I had my first daughter and left the public defender to open my own law firm. I first opened it. I had two. I had one in Buckhead, and I was in office with some other lawyers, and then I had an office in Cobb County. And I have been, since 2008, I've been in private practice. 95%, I would say, is criminal defense litigation. 5% is civil. It's usually things like this where I have to get involved somehow, or my expertise as a criminal litigator somehow comes in handy.
So can you tell the court a little bit about whether you've been recognized in your field of practice?
Yes, I have. I've received a number of honors. I am the current, like I mentioned earlier, I'm the current president of the Georgia Association of Criminal Defense Lawyers, which is kind of a long track. So I've been on the executive board for 5 years. I've been a super lawyer for over a decade. I'm old enough to be super lawyer, not rising star. But before I was 40, I was rising star. I have received on the Rise Award from the Daily Report, received a year ago an honor from the Southern Center for Human Rights with you about our work in a civil action case that we had, a very large plaintiff's case, doing public interest type work, but have definitely received the Cobb Bar Award for Champion of Justice, received Gachtel's Award for Champion of Justice. So I've been very blessed.
And the work you performed in this case, can you explain to the court how you and I divided up the labor in the case?
Oh yeah, that's easy. I do the facts. John does all the civil stuff, and I do mostly the facts. So anytime there were like a factual basis that needed to be written, that would be my job, determining all the facts and keeping records of all the facts and keeping all the documents clear. The actual, the legal drafting we would do together to a certain extent, but you would do the primary legal drafting and then I would just assist in it.
Your Honor, may I approach?
Yes.
Merchant, I'm handing you what I previously marked as plaintiff's exhibit number 23. Do you recognize it?
Yes.
Mr. Merchant, I can't hear you when you're walking back to this podium.
I asked her, I'm handing you what I previously marked as plaintiff's exhibit number 23. Do you recognize it? And she said yes.
Yes.
What is it?
This is our expenses. The first couple pages are input into a program we use called Clio, and then it's all receipts from all of our expenses in this case.
Is it a true and accurate copy of our expense report for this case?
Yes.
Your Honor, at this time, plaintiff would move into evidence plaintiff's exhibit number 23.
Mr. Bowen,
No objection, Your Honor.
exhibit 23 is admitted.
Can you tell the court what our total expenses in this case are prior to today?
$1,339.23.
And to be clear, are you the one that put the entries in the document?
No, my paralegal did.
Have we had discussions with Ms. Bergdorf about that?
Yes, we have.
And you're clear from that document that these all relate to this particular case?
Yes, I am.
Ms. Merchant, when you sent all the requests, whether it be to the county, to the DA's office, in any shape or form, did you do so in good faith?
Yes.
Okay. And when you and I filed this complaint, did you do so in good faith?
Yes.
That's all I have, Your Honor.
Okay, thank you. Mr. Bowman?
Thank you very much, Your Honor. All right, Ms. Merchant. So when in this case, who is your attorney in this case?
John, and myself. I mean, I'm an attorney, so, it's myself and John. We're a small firm.
So you are representing yourselves effectively.
Yes, I'm, one of them, but John does the majority of the litigation in civil cases.
And then a little bit of an odd question to ask given circumstances, but do you have an engagement agreement with the firm regarding this case?
I don't think so, but John would know.
Your Honor, we'll stipulate that we did not hire.
I was going to say, I don't think so.
Okay. With that said, was there anything other than what you already discussed about how you determined the rate that would be applied for your service in this case?
Like why a certain rate?
Yeah, how did you settle on the $300 figure?
Because it's a public agency, because this is the county. I mean, it's reasonable for the county. I mean, I don't currently, but historically, I've done plenty of appointed work, and I always have a reduced rate for that. Like I do it for the federal government, for the 11th Circuit, and it's always at a reduced rate. So
essentially your rate for government work.
definitely.
Now, has anybody other than you and Mr. Merchant, has anybody else been reviewing the time spent in this case to determine the reasonable amount of time?
Reviewing our time, is that what you asked?
Yes.
No.
Okay. Is there anyone else working to control the costs or direct the litigation in this matter?
No.
Okay. Did the potential, back up. We've seen a number of orders entered in the case regarding cameras in the courtroom and media related to this case. Have you coordinated with any media entity at all regarding this case or the hearings in this case?
I haven't coordinated. I will say that if someone calls me, my policy is always if someone calls me and asks me for a document that's a public record that's already on file with the clerk, if some news agency calls and asks me for something, if it's already a public record, I have no problem sharing that.
Have you reached out directly to any media organization or reporter or other individual to proactively reach out to them to discuss this case?
That I've reached, like I've initiated the contact?
Yes, ma'am.
I wouldn't say I've initiated any. I mean, there are reporters that I talk to that I'm friends with that have asked me about the status, but I don't think the one I'm thinking of, I don't actually think has ever reported on this case.
Is there any other, without revealing the substance of any such conversation, have you discussed this case with any other attorney, other counsel on the criminal matter that's related to some of the issues here?
There's more than one criminal matter, I think, that could be related. I have told some of the other lawyers about the status of this case, if that's what you're asking.
Okay, have you discussed any strategy with any other counsel?
No, not strategy.
Okay. Anything about the factual underpinnings of the case with the other counsel?
The facts of the case, I have definitely, I mean, John and I are lawyers, like we talk to lawyers. So yeah, I definitely have talked to other lawyers about the facts of the case.
Okay, are any of those lawyers representing co-defendants in the case in which you represent Mr. Roman?
I have told lawyers in the Roman case about some of the facts in regards to open records.
And again, without revealing any attorney-client substance, have you spoken with Mr. Roman about this case?
Yeah, but not really at any great length. Well, because this case, so when you talk about this case.
Hold on.
Well, yeah, let me interject here for a moment. Let me say this. I understand certainly that part of the DA's position, the defendants, the district attorney's office and Madam DA in her official capacity, is that perhaps these requests were not substantially justified because they were intended for use in the prosecution of Michael Roman, right? I absolutely understand that. I don't know that it's an efficient use of our time to sort of beat that horse, because I certainly understand that that's the position of the DA's office.
And Your Honor, the reason that I bring it up is, number one, counsel opened the door with discussion about good faith and the good faith activity in the case. I think it goes a little bit to good faith when we're talking about the level of publicity that somewhat this case, but certainly the other case have generated, and the interest in the goings on at the DA's office in particular, and as well as the some of the expansion and all the subpoenas, specifically including the subpoena to Madam DA herself in this case. I do think it goes to the reasonableness of that, and then therefore the reasonableness of the attorney's fees.
Okay, fair enough. Mr. Merchant, your response?
Yeah, I didn't know.
Mr. Merchant, if you could sit down and be on the mic.
I'm a slow learner. My wife can tell you that. Well, I did open the door to attorney-client waiver. And he specifically asked her, what did you talk to Mr. Roman about? She is his counsel in a separate case, so he cannot inquire as to communication she had with her own client, even if it's marginally relevant, which I don't think that it is.
Well, there are a number of privileges that would attach in terms of attorney-client work product, et cetera. I mean, I think the point's been made. And to the extent you wish to inquire further, I'm not saying you can't. I'm just letting you know, I get your point about that aspect.
And I just note, Your Honor, I didn't ask about specific conversations, just whether she had spoken with Mr. Roman.
Fair
But
enough. Go ahead.
With that said, I'll continue on. Has there been anybody else outside of you and the members of your firm, Mr. Merchant, who have provided any input or funding at all into this case?
No, haven't gotten a dime.
Okay. Do you have any agreements or discussions with any outside parties regarding anything that regarding the proceedings in this case?
No,
Okay. Has any of the work in this case been billed to clients in Mr. Roman's case?
no,
Has any of the documentation that you've received in this case been utilized in that case?
no. In this litigation now.
In the subject of this litigation?
Right, I want to make sure you weren't saying in response to any open records.
No.
Because early on, so when we filed it, just to qualify, just to make sure that it's perfectly clear, when we filed this litigation in January, there were a number of outstanding open records requests that were also part of this litigation originally. Those, I was able to subpoena those documents when I had a hearing in the Roman case. And some of those specifically were things like invoices, things like that. So I asked for those under open records. I didn't get all those. So they were initially part of this litigation. But then when I got a hearing date in the Roman matter, I was able to subpoena those. And so I was actually able to get those so they didn't have to stay part of this open records.
Thank you. I do want to go back to Exhibit 24 in this case, which was the description of the work performed. Now, we talked about this case having been filed in late January of 2024. And I'm looking at page 1 of Plaintiff's Exhibit 24, and I'm seeing entries that begin in September, going up through onto page 2, going to all the way up through prior to filing the complaint in this case. Is it your contention that the correspondence and the issues that were dealt with prior to the filing of this case is something that should be included in attorney's fees?
Yes, because it was all part of what I had to do to get responses to the open records. If you look at page 1, and you know what you're referencing on the second page, page 2. So how it's supposed to work is I'm supposed to file an open records, ask for the document, and then you all give me the document. When it doesn't happen that way and I have to follow up and email and beg and plead and explain again and again for months, that's all part of what is leading up to the litigation. And that's what you'll see on the first page. Follow up on email, follow up on ORA response, send another email. And you actually, okay, so to answer, I'm glad this is in front of me now. I can qualify my answer earlier. The complaint to the Attorney General was in October, October 17th. So I filed this lawsuit in January. I mean, these issues were still outstanding. So clearly the Attorney General complaint wasn't gonna fix things. But no, all of these are part of pre-suit, I guess, work is what you could talk about. And let's just be clear, if they'd been complied with over this 6 months, there would never have been a litigation. But like November 29th, send an email following up with the county regarding
I
ORI.
haven't asked you a question at this point, so I appreciate that. If you could give me just 1 second, Your Honor, just to make sure that I've hit everything. Double check. just in case there's any redirect.
Thank you, Mr. Bowman. Mr. Merchant?
Yes, I just have one question for you. So Ms. Merchant, if we had to hire outside counsel and they had to read all the correspondence that you had sent to the county and to the DA's office, and got up to speed, done all the legal research and all of that, and we paid them their rate, would it have been more expensive for us to do that or less expensive than handling ourselves?
Way more expensive, cost prohibitive.
That's all I had.
Okay, I have a couple of questions just to make sure I know what the exhibits are that I'm looking at. I heard Exhibit 23 being identified as a document supporting claimed expenses of $1,339.23.
That's correct. Your Honor.
Okay. And then separately, Exhibit 24, which some questions, I mean, I've seen that it is a table with individual entries of time. What I was less clear on is this as to all time expended by the Merchant Law Firm, or is it just as to Ashley Merchant?
This is my time.
Okay,
This is my time.
thank you.
And then do you want them?
Yes, please.
Thanks.
Thank you. Anything, was that the only question you had? Anything else, Mr. Bowman?
No, Your Honor.
Okay, Ms. Merchant?
No.
Yeah, that was all I had. You may be excused. Mr. Merchant, does anyone have any additional witnesses? Also, don't touch the microphone.
Yes, Your Honor. We're going to call our paralegal, Sierra Bergdorf.
Okay, Ms. Bergdorf? Face me. Do you swear that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated. And same caution, be careful of that chair next to the ledge, and scoot up to the microphone and state and spell your name for the record, please.
Sierra Bergdorf, Sierra, last name Bergdorf, Burgdorf.
Ms. Bergdorf, is this the first time you've ever testified?
Yes.
Your Honor, may I approach?
Yes, you may, but just don't talk while you're doing it.
Thank you.
So I've handed you two documents. Let me focus you on what's pre-marked as Plaintiff's Exhibit 26. Do you recognize that?
Yes.
What is it?
This is my timesheet.
Okay, is that a true and correct copy of the time entries you made on this particular matter?
Yes.
Okay, and are all the entries in there, do they appear to be the way you drafted them?
Yes.
Okay, Your Honor, at this time, plaintiff would move into evidence, Plaintiff's Exhibit 26.
No objection, Your Honor.
Exhibit 26 is admitted.
Okay, can you tell the court how much time you expended on this matter?
My total time is 65.4 hours.
Did you have any role whatsoever in determining what your hourly rate was?
No.
Whose decision was that?
Yours.
All right, let me turn your attention to Plaintiff's Exhibit 28.
Okay.
Do you recognize that?
Yes.
What's that?
This is the affidavit,
Whose affidavit?
mine.
Okay, is that a true and correct copy of the affidavit you signed?
Yes.
Okay, and you actually drafted most of that, right?
Yes, I did.
What role did I have in helping you draft that?
You just reviewed it.
Does it lay out your experience?
Yes, it does.
And let me ask you to tell the court a little bit about what your position is and what your role is in our firm.
I am John and Ashley's paralegal. I wear a lot of different hats as their one employee, but I mean, in this particular matter, I assisted with drafting and preparing and compiling exhibits, reviewing documents, outlining timelines based on documents that were and were not produced.
1 second. I want to hear, I need to hear. Sorry for the interruption. Go ahead.
So the entries that you made on plaintiff's 26, are any of those administrative in nature, or are those all what we'd consider more substantive paralegal work?
Substantive paralegal work.
Because you mentioned you do a lot of things for us,
Yeah.
answering phones and, filing and all that sort of stuff. But does this document contain any of that?
No, this is all stuff that can be billed for.
Okay. And how did you put this document together?
I had an open Word document and I would just track time as I went along with whatever tasks were directed to me.
Okay. And who told you to keep your time?
Mr. Merchant, you did?
Okay. Your Honor, that's all I have for Ms. Bergdorf.
Thank you. Any questions, Mr.? Wait a minute. I apologize. You offered Exhibit 28 and you had the witness identify it, but I don't know that I ever admitted it.
That's absolutely correct, Your Honor. Your Honor, at this time, we'd move into evidence plaintiff's Exhibit 28.
Mr. Bowman?
Other than I believe it's 26, Your Honor.
Well, 26 was her timesheet, which I thought I did admit, but 28 was an affidavit about her experience.
Oh, I apologize. I just don't have that one in front of me. That's why I was confused. But we've received it, so
Okay.
no objection.
Okay, so Exhibit 28 is admitted, and just to be clear to Mr. Bowman's point, if I didn't say it before, Exhibit 26 is also admitted. Thank you. Mr. Bowman, any questions for this witness?
Just one, I believe, Your Honor. And Ms. Bergdorf, good afternoon. You mentioned that Mr. Merchant reviewed the document. Did he make any substantive changes to that document?
No.
That's all I have. Thank you.
Thank you. You may step down. Mr. Merchant? Plaintiff's next witness?
That's me, Your Honor.
Okay. Are you going to stay in your place, or is Ms. Merchant going to cross the stand?
I certainly hope not to be.
Doesn't seem like a fun thing to happen.
No, I do not want to be cross-examined by Ms. Merchant today, if
Okay.
I can avoid that.
Any objection to Mr. Merchant stating in his place regarding his fees and qualifications?
No, Your Honor, as a fellow husband, I would not do that to him.
Go ahead, Mr. Merchant.
Yes, Your Honor, I'll state in my place that plaintiff's exhibit number 25 is my statement of time. It is a document similar to that for Ms. Merchant and Ms. Bergdorf. I will state that it's true and correct, that it accurately reflects the amount of work that I performed on the case, the nature of the work I performed, and it's itemized on the day that I worked in 0.10 increments, as I was trained to do as firm lawyer. The total amount of time that I have, let me just first move it into evidence. This time, plaintiff would move into evidence, plaintiff's 25.
Mr. Bowman?
No objection, Your Honor.
Exhibit 25 is admitted.
And my total number of hours on this case prior to today, I should say prior to today, that does not include the work that I did over the weekend for Your Honor, is 89.1 hours at a rate of $300 per hour, which was determined in exactly the same fashion that Ms. Merchant's rate was determined. We graduated law school in the same year and became lawyers at around the same time. So I've been practicing for 21 years. The hourly rate of $300 per hour is significantly lower than what I would charge based on my experience. It's also certainly lower than the rate that would be charged by outside counsel had we had to retain outside counsel. The total attorney's fees that I have to date in the matter is $26,730.
I'm sorry, say that again?
$26,730.
Okay.
And for Your Honor's benefit, I've broken down for some of the, and as Your Honor has probably figured out, I did a lot of the drafting, primary drafting. I'm the one who put together the complaint, the amended complaint, the second amended complaint, motions to add defendants. I responded to most of the legal pleadings that were filed by the defendants. So these fees reflect that. And I will say, in terms of the fees themselves, many of them were incurred because of the litigiousness and the litigation history in this particular case. So I have broken down in my affidavit, which I'll get to in a minute, certain amounts of time that were spent specifically for the dismissed defendants based on my time entries.
And that was Exhibit 25. Timesheet, it's already admitted. Is your affidavit going to be
Yes,
Exhibit
30.
Thank you. And also, I don't know that I got Ms. Bergdorf's Exhibits 26 and 28 as the actual exhibit.
I'm going to hand them all to you
Thank
in
you.
one grouping, Your Honor.
Fine.
Yeah, this is both.
So, Your Honor, I'm looking at Plaintiff's Exhibit 30. This is my affidavit that is dated I didn't date it. Oh, here it is, October 18th. It's a true and correct copy of the affidavit I drafted. It sets forth my employment history and my work on this case. Specifically with regard to my timesheet, I've broken down certain entries by certain defendants. It outlines our costs in the case. And at this time, I'd move it into evidence. Plaintiff's 30.
Mr. Bowman,
No objection, Your Honor.
Exhibit 30 is admitted.
So as I was pointing out earlier, Your Honor, in paragraph 8 of my affidavit, I've laid out for the court, should the court not wish to grant us fees for any particular dismissed defendant, I've laid out exactly where I spent time that was solely devoted to the two defendants who've been dismissed. The rest of the work was a collective work involving all the defendants, because in many cases they had overlapping arguments, or they all filed the same type of motion. So for the most part, with the exception, I think, of 8.2 hours, all of the hours that were identified in my cost sheet were all reasonable and necessary in light of the work that had to be done. Unless the defendants have questions for me, which they may, and I can take the stand for those if they want. That concludes our evidence, Your Honor.
Mr. Bowman, do you have questions for Mr. Merchant?
Just a very few. Just a
Mr.
couple.
Merchant, come on up. You'll raise your right hand, please. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated. Careful about that ledge. And if you would, please lean into the microphone and state and spell your name for the record.
John Merchant, JOHNMERCHANT.
Thank you. And Mr. Merchant, thank you for being here and for answering some questions here real quick. Very similar, with respect to this case, have you had any discussions with any outside counsel or other counsel on the criminal matters that we've discussed previously? Have you spoken to anybody regarding this case in that matter?
Let me see if I understand.
I'll rephrase it a little bit. Have you spoken to any either defendants or counsel in the case involving Mr. Roman regarding the issues in this case?
No.
Okay. Have you had any conversations with any media entities or reporters regarding this case at all?
No, I leave that to the other merchant. Was the ongoing criminal matter a factor in any manner in how you developed either the theories or the complaint in this case? No, absolutely not.
And are any of these documents that have been received in this case, are they being utilized, or do you have plans to utilize them in the criminal matter?
I don't represent Mike Roman currently.
Okay.
This merchant does.
Are you aware of any plans to do such?
To represent him?
No, to utilize the documentation.
No.
Okay. All right. And has anybody outside of your firm discussed this case with you or the strategy in the case?
Not the strategy. The fact that it's pending, yes, because other lawyers have asked me about it.
Okay.
So I have spoken with them about the status of the case, yes.
Who have you spoken to?
To name people individually, I'm not sure. Whenever I'm in the courthouse, people will ask me about it, generally, from Cobb to Fulton, wherever.
Are any of those people?
There are a lot of folks who've asked me questions. I could be here all day telling you exactly who.
Are any of those people involved in the litigation in the criminal matter, to your knowledge?
I'm sure at some point I did speak with some of the lawyers representing defendants in that case about the open record suit, but it would have been in passing and not in any detail at all.
Are you able to identify who those people would have been?
It's the defense team in that case. That I think you know who they are.
Did they provide you any input or advice on this case?
No, absolutely not.
Okay. With that, Your Honor, I don't have any other questions.
Okay. Anything else to rehabilitate yourself?
No, Your Honor.
Okay. Thank you, Mr. Merchant. You may step down. Any additional evidence, Mr. Merchant? I think you said that you were concluded, but I wanted to make that more formal.
Yeah, no, we rest.
Okay. Do the defendants have a motion or the defendants have evidence, or which order do we want to take that up in?
No further evidence, Your Honor.
Okay. Do the defendants have a motion?
Yes, Your Honor, we have a motion that we're allowing Ms. Allaby to argue for the purpose of arguing this motion. Just some background information as to why we could not sign off on the motion. Mr. Bowman and I were away on vacation, and there were meetings and recent discoveries that we were not a part of and we could not speak to nor sign off on. We did not have personal knowledge of this. And given Ms. Allaby's connection to this case and the information provided to her, she would be the best person to draft this motion and speak to this motion, and we're giving her limited permission to do so for the purposes of arguing that motion.
Okay. Go ahead. Let me go back a moment to something I said at the beginning, right? In terms of the motion that you actually filed, which by the way has now been accepted, and I can see it in Odyssey. I just wanted to restate what I had said about, I think, the most efficient way for us to handle this. I understand that part of your position is that you're going to seek sanctions, et cetera. Also, right now, procedurally, the appropriate action here, right, is going to be a motion for directed verdict, I understand from you, which is also what was filed. What I wanted to be clear about is that now is the time for you to argue a directed verdict, which goes to whether or not the merits of the underlying claim have been satisfied in the principal case, number one. To the extent that you wish to ask for sanctions or attorney's fees, my belief is that that matter is not yet right. And so if you can please try to isolate your address to the court now to focus on the extent to which you believe the plaintiffs have not offered evidence that would satisfy the required elements of their claim, subjecting it therefore to a directed verdict.
Okay. I think I'm clear on how the court is directing me. And thank you for the opportunity to come before you, Your Honor. We are asking that the court make a finding in our favor. At this point, the court has heard the evidence in this case. You've heard testimony in this case. You had the opportunity to hear from our chief of staff, Mr. Bond. You've had the opportunity to hear from the plaintiffs in this case. The record is also supplemented with multiple affidavits and business record certifications and responses to the plaintiffs' request. And so there is a clear record that the plaintiff has not met their burden under the law with regard to a finding in favor of the plaintiffs. Judge, we are here, and I'm going to try to thread this needle as gently as I can. Our position is that we are here not because the district attorney's office or Madam District Attorney Fani Willis was not responsive to the plaintiffs. To the contrary, the record is clear that we were in fact responsive to the plaintiffs. But there has been no evidence that has been provided, only argument and supposition that the district attorney's office has not complied with the Open Records Act or acted without justification in this matter. We have not been negligent in any of our actions with regard to the multiple open records requests in this case. And Judge, in all candor to this tribunal, the reason that we are here is not because of this Open Records Act. We are here because of the criminal case that is pending against Michael Roman. This open records suit has been filed in order to essentially get information to relitigate the disqualification that was heard in the criminal case and to add credence to plaintiff's argument with regard to that. It is not lost on the defendants in this case. When this lawsuit was filed back in January, on January 30th of 2024, mere days before briefs were due in the criminal matter, that is not a coincidence. It was intentional to add credence to calls for disqualification of the district attorney in that criminal case. This entire lawsuit, this case, and why we are before this court is to accomplish three goals on behalf of this plaintiff. It is to impact the criminal prosecution of her client this upcoming election. It's our position that there has been bad faith on behalf of the plaintiff and that this suit is being used to harass and intimidate the district attorney. And I will save the unjust enrichment portion for later as pursuant to the court's direction. But the district attorney's office, District Attorney Willis, have established by and through testimony in the record that there is absolutely no reason to find in favor of the plaintiff at all whatsoever. And essentially, we are relitigating a number of issues that took place in the criminal prosecution and the disqualification motion. And unfortunately, the plaintiff, like I said, filed this suit in order to bolster her assertions in that criminal case. That should not happen. We should not be relitigating matters here. The information that is requested.
Well, forgive me for interrupting, but let me just be clear. We're not relitigating any of those matters because I have no authority and thankfully no responsibility to relitigate any of the issues associated with Mr. Roman's prosecution or that larger prosecution.
I understand the course. I'm sorry.
Right. And so I'm just saying, I promise you that I will not take up any invitation to relitigate those issues because I don't want to and I don't have the authority to do so.
I understand. It is our position that that is what the plaintiff is trying to do here. It is our position that that is why this suit has been filed. It is our position as to that is why we have received and been inundated with a number of subpoenas. Subpoena power has been abused in this situation, as it was similarly in the criminal case. We have a number of individuals within our office that were subpoenaed pursuant to this case that is before your honor that were never even called as a witness. District Attorney Willis, the plaintiff's asked to hold her in contempt, did not properly subpoena her. It's all explained within this motion, did not properly subpoena her, have not filed in notice or anything of that nature. A signed return receipt was not filed with the court pursuant to the law. I would refer the court to the case of Harkness. Let me get the citation for you, Your Honor. Harkness versus State 225, Georgia Appeals 864, 1997 case, which states very explicitly, and in that case, the appellate contended that his trial counsel was ineffective and he failed to secure counsel's attendance for a motion for new trial. Harkness attempted to serve trial counsel by way of certified mail, and the court noted in that case that proof of service of a subpoena in this matter requires the filing of a signed return receipt with the court, and the same is not in the record. It's directly analysis.
Let me interrupt. Okay, so this is why I wanted to separate out some things. So a good bit of what you're complaining about now, right? I can't give anybody legal advice, but there's a procedure for you to say that that was in bad faith and that we incurred attorney's fees or whatever associated with a party who was ultimately dismissed. Like there's a process, but right now the issue in front of the court is, and this is what I'm struggling with. To my understanding, there's never been a dispute that the records that were requested by the merchant law firm are public records that are subject to the ORA. I've never seen it asserted as a defense in this case. I've never heard it argued by any of the attorneys in this case that the records sought were not public records that are subject to the Open Records Act, separate and apart from the ruling I've made that the DA's office is subject to the Open Records Act, unless, of course, the Supreme Court tells me tomorrow that I'm wrong, right? Mm-hmm. So if they are in fact open records and the request made by the merchant law firm was clear enough that the custodian could understand what was being requested and attempt to comply with it, does the fact that an attorney intends to use those public records to their advantage in another piece of litigation, why does that matter?
Judge, I think it all is related. We in the district attorney's office are dealing with a plaintiff who has filed a complaint, has alleged all manner of information about the criminal case throughout that complaint and the amended complaint concerning the criminal case and why she's requesting this information has been expressed and has not hid at all at any juncture of this case or any other case that her purpose and the goal of requesting these open records, requesting this documentation that she has provided to the district attorney's office is to undermine the criminal prosecution. I think it's all intertwined in why we are here, why this case was filed, why it is.
Right. But respectfully, so there's two issues I'm hearing you say, and I think they're separate, and I'd like to get an answer separately. One is this aspect of harassment of the DA's office. That's a separate thing, okay? I obviously want to be sensitive to concerns that that's what is trying to be accomplished through this litigation. But we're going to put a pin in that for a moment right now. My question is, as a zealous advocate for their client, what is wrong with an attorney saying, I am aware that there are public records that I can request through a statutorily allowable procedure that I might use to assist in the zealous defense of my criminal defendant client? What is wrong with that?
Judge, I've never said anything is wrong with zealous representation. Prior defense attorney right here. I believe that it is important that we have defense attorneys who zealously advocate for their clients, that look at all possible defenses, that make sure that they are covering every base. That is not what is happening here. That is not why we are here today. We have something that is very different. And my perspective, my view, our position we submit to this court is that it is so intertwined with why this lawsuit was filed, that zealous representation is one thing, but to use the open record statute in order to harass a district attorney, to file filings into the record, in this case that is before your honor, that our position is not accurate, to assert to this court that there are documents that were not received that we know that were in fact received, or we have a situation where we have a plaintiff that is making assertions that there are these additional documents, even though she has been given responses, she has been communicated with, that we have been nothing but responsive to her request regarding the multiple open records requests that we have received. Now, even receiving the responses from the state, we were still met with this assertion that, one, we were derelict in our duty in some regard, that we were negligent in some regard, that we have not complied with this statute. And what I am trying to probably and artfully communicate to this court is that those assertions were made for the sole purpose of undermining the prosecution in the criminal case. That has been the driving force of what led us here. And that is very different than zealous advocacy. We are outside of the realm of zealous advocacy. The records are public. She can use it however she chooses to. But whether or not there have been factual assertions that this court can actually consider outside of, speculation, assumptions, just my belief or my thought is this, facts and evidence that will suggest that the district attorney has did something other than comply with this open record statute is not here. The record is void of that. This court actually has a record that not only shows but proves that we have not just exercised our duty, but we have gone a step further, because as the plaintiffs have said at some point during their questioning today, this situation is very litigious. We know, we not just know, but it is a tenet of District Attorney Willis to make sure that we are being transparent in our dealings. These accusations, this lawsuit suggests otherwise. And what I am trying to communicate to the court is that suggestion is not because there is a legitimate basis. It is because plaintiffs wish to use that in order for Michael Roman to get out from underneath his criminal case. The appropriate and proper way to handle that situation is to allow that man to have a trial. People have a right to a jury trial. People have a right to defend their clients.
Right, but again, I apologize if I sound like I'm beating a dead horse here, but again, what I'm struggling with is whether any of this information is intended for or will be used for. I question whether that's relevant to a determination of were these open records, were they clearly requested, were they provided, or was a good faith effort made to find them and provide them? And ultimately, whether they're admissible in evidence for any purpose against Mr. Roman or in his behalf is a decision for a different judge in a different proceeding. What I'm struggling with here is I don't understand why the fact that first of all, to be clear, I understand your argument, but Ms. Merchant has testified that she either doesn't intend or hasn't made a decision. That's not the purpose for why she requested these records, because the ones she wanted regarding Mr. Roman were ultimately obtained through subpoena in the criminal action. So she has affirmatively, and I think Mr. Merchant also said that that's not the intention here, that some of this was for a project associated with Gactyl or something like that. But setting that aside, I understand that you are somewhat disbelieving of that representation. Again, what I'm struggling with is, okay, if an attorney knows that there is information that might help their client and they are legally authorized to get it, what's wrong with them saying, here's my Open Records Act request, give me those documents, and then seeing if the trial judge will let them use those documents?
Again, Judge, I don't think that is not an appropriate thing to do. What I'm saying is that's not what happened here. I'm saying that the plaintiff's complaint and their amended complaint say the contrary of what was testified to right here today, that the purpose of this litigation, the purpose of this was to use these documents in the criminal prosecution. But putting that aside, Judge, here for the open records suit, we have direction and guidance from our Supreme Court, and I will draw the court's attention to Felker versus Lukemeyer, 267 Georgia 296. It's a 1996 case where an individual was requesting documents from a public entity. But there was a line in this case that is so poignant and so on point to what we have here that states the legislature could not have intended for an open records request to be used to trap an unsuspecting public official. And we have this game of gotcha that the plaintiffs are trying to, impose upon the district attorney. Notwithstanding all of the other matters and cases that we have, people request records from our office every single day. We are inundated with open records requests.
Even though the official position of the DA's office in this litigation is that they're not governed by the Open Records Act. Just saying.
People request it. I have no control over what people request.
But if you don't give them, they apparently can't be enforced against you because the law doesn't apply to you according to the official position of the district attorney's office and the Fulton County District Attorney in this lawsuit. Just saying.
And I'm saying that people make their requests. They reach out to our office. They ask for the documents they wish to ask for. That is their prerogative. They can reach out to any office and make any requests that they want. What I'm saying is that this particular lawsuit has made it this far, not because of the merits, not because there was some type of inaction on behalf of the district attorney, not because there was some type of hiding of the ball or not providing documents to the plaintiff because they requested it. We are here today because of exactly what I stated, Judge. It is not because the plaintiff did not receive something. It's not because the district attorney is playing hide the ball. It is not for any of those reasons. It is because, and I understand the court's position with regard to this, but it's because the plaintiff wishes to undermine the prosecution in the criminal case. Use those records for however you choose to use them. We did provide them. We did, in fact, provide the records to the plaintiff. During the pendency of this litigation, we have received a number of emails. We've received correspondence. I will note for the record before this honorable court, District Attorney Willis and the District Attorney's Office are both represented by counsel. Plaintiff has still reached out, completely gone around and usurped our professional rules of conduct, our duties as attorneys, has not reached out to me. I've sat in this courtroom. When I came to make my argument for the motion to quash, the court very wisely said, why don't you accept service now? I was not for that. I was a little opposed to that. I sat in this courtroom for days as we heard testimony from Mr. Bond, still did not get served with anything. Still did not have the plaintiff at least adhere to the basic and minimum requirements of our duties as attorneys, our duties as counsel. All of this is illustrative of why we are here, why the claim has no merit, why there is no basis for this sham of a lawsuit, for this waste of the court's time that we are here for. This is an attempt to obstruct justice. This is an attempt to make sure that there is a news clip or a news bite with regard to this that uses Madam District Attorney's name, because quite frankly, without her name, these news cameras would not be here. What I am telling this court is that there should not be, and I'm asking this court to not rule in favor of the plaintiffs, to rule in favor of the defendants, because based on this record as a whole, evaluating the record as a whole, the filings that were made ahead of testimony, assertions from plaintiffs about not needing injunctive relief, and now we're here on injunctive relief, the multiple requests are not even the issue because, again, plaintiff has received those things. It is truly the conduct, the extension of this lawsuit in order to ask for those attorney's fees, and I won't go any further than that. But all of this is to serve a particular purpose, and it is not because they did not receive documents. It's not because we are violative of the open record statute. It is to undermine this prosecution. It's to impact this criminal prosecution, the election, and to harass the district attorney's office. And as such, we are asking that this court find in favor of the defendants.
Thank you. Mr. Merchant, your response? Hang on just one second. Can you come here, Ms. Johnson? Yeah. Go ahead, Mr. Merchant.
Your Honor, that was a political speech. Ms. Alibi didn't answer any of your questions directly. She was sent here to say a certain thing, and she said a certain thing. I'm not going to give you a political speech. I'm going to talk about the law. The Open Records Act makes clear, Your Honor, in the very first paragraph of the statute, that it is the strong public policy of this state to be in favor of open government, that open government is essential to a free, open, and democratic society, and that public access to public records should be encouraged to foster confidence in government, and so that the public can evaluate the expenditure of public funds and the efficient and proper functioning of its institutions. That's what these requests asked for. Many of the requests asked for how the DA's office spent money. Many of them have nothing to do with the criminal case, as Your Honor has appropriately pointed out, yet we continue to hear this banging on the table about this being some sort of politically motivated or media motivated type of action, and it is not. We are here because the DA and the DA employees, in particular, Mr. Bond, refused to comply with this law. Ms. Merchant and I are fortunate enough to have the resources to be able to put us in this spot so that we could actually argue the law to Your Honor and highlight the failures here. As Your Honor has pointed out from the first day we set foot in this courtroom, you have been appropriately focused on the real question here, which is, are they subject to the act? You have ruled in your on the motions to dismiss it that the two remaining defendants are subject to the act. Are the records that are sought public records under 1870A? The Willis case requires them, that's Willis versus Greene County, it's 274, Georgia Appellate 776, that's a 2005 case, deals with the idea that they can't just send us a letter within 3 business days and say, hey, we're on that. That's insufficient as a matter of law. Not only do they have to send us something in writing or to let us know that they're going to respond, they have to tell us whether they're going to give us the documents or not. And then reasonable accommodations can be made after that. They haven't even argued that they complied with that portion of the statute. So we've crossed that bridge. They haven't asserted any legal basis for any exemption under 1872. So we don't even have them taking a legal position that they're not required to give the documents in the first instance. So that leaves us squarely on the substantial justification prong of 1873B. That is the remedy in the statute for us. There is no other remedy. You're it, Your Honor. If you say we have failed in this endeavor and you do not grant us, you don't render judgment in our favor and grant us fees and expenses, it is going to send a message across the state of Georgia that virtually nothing that is done by the DA's office in this office or any other place will be held accountable under the law. And we think they have failed to rebut our allegation that they were not substantially justified in failing to comply with the act. Because I don't think there's any real doubt here or dispute that they haven't given us the documents or didn't give us the documents in time. There's a lot of this, well, we gave it to them, we gave it to them, we gave it to them, months and months later. There's nothing to see here, Judge, because they've gotten the documents now. That's not the issue. The issue is it took us 8 months of litigation to get here. And they only gave us documents in piecemeal fashion only after we forced their hand, only after we filed the lawsuit, and they were held to account for it by filing legal responses to us. It took that judge not picking up the phone and saying, hey, what do you really want there? And trying to find a way to make it more transparent, which has been talked about a lot, and which is the underlying premise of the whole act itself. They didn't do that. They hid stuff. They changed the documents. They altered the documents, and they did it on purpose. I'll get to the Ashley Merchant rule in a second, but as I pointed out in the letter yesterday, Your Honor, 915.14 is our abusive litigation statute in the civil world. This is a civil action. There's no, I couldn't find any guidance in the case law surrounding the Open Records Act that defined what substantial justification for their failure to comply, what that actually means. So I had to go digging in the abusive litigation statute, and that statute specifically defines substantial justification as, lacked substantial justification as meaning substantially frivolous, substantially groundless, or substantially vexatious. Well, frivolous and groundless both can be satisfied by the plaintiffs, by us, by showing that they lacked a legal basis for their arguments. And we've demonstrated that they have not raised any legal basis for their arguments. So we win on both frivolous and groundless under the statute just by showing they didn't assert a legal basis in their defense. Groundless also could include a factual basis, an excuse, if you will, for why they didn't comply. That is where I think Your Honor has some questions to resolve regarding Mr. Bond's testimony. You, of course, with no jury, you're the trier of fact.
Sorry, Mr. Merchant. Let me interrupt you for a second. So first of all, let me just ground us again for a moment, because it is a non-jury trial, because I am the trier of fact, because, you know, we're forcing procedural pit stops along the way that don't come naturally when it's just a bunch of lawyers in here talking. But technically what you are talking about right now is a response to Ms. Alabi on behalf of the two defendants' motion for directed verdict. And I understand you need to address each of those elements, but it sounds like you're starting to stray into argument about why you think you should win, as opposed to just argument about why I should direct a verdict against you.
And I was doing that, Your Honor, because
Okay.
I was sitting there thinking to myself, well, am I going to do a closing separately from this with no jury, or am I just going to go up there and talk?
I mean, if you feel like it's all the same thing, I'm okay with that. I just want to make sure that we sort of know where we are.
Yeah.
And the reason I say that is that I would still end up wanting to hear from the county attorneys in terms of their position about the substance of the case, separate and apart from the DB.
Yeah, fair enough, Your Honor.
Okay.
Then I'll focus very specifically on direct verdict issues.
Yes, sir.
So the standard in the civil case is preponderance. So the only thing we have to do is show, Your Honor, that we're more likely than not to prevail, and we have to demonstrate that we've carried the day on certain factual issues related to the elements of the statute. So what we've already talked about, the first two or three elements, we've satisfied all that because there's no evidence that they raised any defense that would require us to bring evidence to dispute it in the first place. So it's conceded. So the real issue is, did we give Your Honor enough facts to reach the trier of fact yourself to consider the issue as it relates to substantial justification? So let me talk to you about Mr. Bond's testimony. So you're the trier of credibility. I think you sat here and you listened to him. We all did. And I think you can understand that our position is he is the personification of the failures in this case. He's the personification of the failures in this case because he specifically testified that he has an Ashley Merchant rule. And the Ashley Merchant rule, which is contrary to his number one rule, means that he doesn't pick up the phone for her, and that he digs in, and he's defensive, and he's obstructionist. The way he testified is exactly how they responded to the open records request. He didn't assume that there was a valid purpose or a legal purpose and then go try to help Ms. Merchant find these things. He did the opposite of that on purpose. He did this because he linked it himself specifically to the timing. And we heard from Ms. Alabi too about this today. He, on the stand, linked it to the timing of the criminal case and the motion that Ms. Merchant filed in that case in January of this year. That's when the wheels fell off. because he wasn't listening. He wasn't trying to comply with the law. He was trying to find a way to parse her requests. He must have said it 4 or 5 times, garbage in, garbage out. So that's his excuse for failing to comply, because he decided, I'm going to determine that's garbage in so I can give garbage out. And he did that on purpose because he was not going to communicate with her. So the excuses he gave, and I think this is something fairly that Your Honor needs to consider, is the credibility of the excuses he gave. Because frankly, under the statute and under the interpretation of the definition of substantial justification, you've got to find, frankly, that you believed him. Not only did you believe him, but that you believed that they were substantially justified in relying on these excuses for failing to comply for some 9 to 10 months. Even in the face of a lawsuit where he I'll get to in a second, claimed he never read, and then said he believed it to be frivolous. So the cyber attack, he claimed at some point that part of the reason they couldn't comply was the cyber attack. That only applied for a very short amount of time. It certainly is understandable that they would have difficulty responding, at least electronically, to certain things because of the attack. We're not questioning that. But what happened when it was over? They didn't go back and start to redo it and fix it. They didn't do anything like that. And not only that, on the stand, he didn't even attempt to link up the cyber attack with any actual delay. He just said in general terms that they had a cyber attack. He didn't say in this specific case how it prevented him from responding to Ms. Merchant appropriately or timely under the law. Excuse number 2, the January 9, 2024 request was not elevated to him. This appeared to be, from my view, someone trying to throw an employee under the bus. That because it wasn't elevated to me, I was not aware of it. We know that's not true. At the time that he testified to that, he was not aware that Ms. Merchant had an email from September of 2023 with he and Erica Willingham on it, showing very specifically that he had talked about critical mention and that they had actually prepared these documents in the prior year. But he told Your Honor under oath that he had no idea what critical mention was in January of 2024. We know that's not true. When he got caught with his hand in the cookie jar, he tried to pivot around it and then finally had to concede, well, yeah, I did deal with that. That's my name. His name on the email was Dexter Q. Bond. He also told you that he didn't know who Dexter Q. Bond was when Ms. Merchant showed him the forfeiture documents with his name on it. It's just incredible. So he's with regard to the failure to elevate, this is, if it's anything, it's a failure to train the employees properly. Let's assume that he didn't have a nefarious reason for testifying the way he did, and that he was actually telling the truth that wasn't elevated to him. Well, it cannot be the plaintiff's burden. It cannot be the citizens of Georgia's burden to train employees who are dedicated and responsible for responding to Open Records requests. It's just not, that can't be a function and it can't be a defense to justify not timely complying with the law. More importantly, Your Honor, if that excuse held any water, it certainly lost all the water by January 26th, because we know he wrote a letter to Ms. Merchant outlining all of the issues. So to the extent it wasn't elevated prior to January 26th, we know Dexter Bond was involved going forward starting on January 26th. So what in the world justifies the period after January 26th through September and even now when we still don't have some of the documents? Excuse number 3, Mr. Bond assumed the first matter was resolved because Ms. Merchant didn't specifically follow up. And when she was on the stand today, I heard questioning about this as well. Did you follow up on every single little thing? And I think Your Honor even asked Mr. Bond, what happens if you say no responsive documents? Is it the plaintiff's burden or the citizen's burden to ask, are you really sure about that? You know, that's not what the law contemplates. The Open Records Act certainly doesn't contemplate us having to cross-examine the agency's responders. We can't do that, and we can't do that for one very important reason, which Mr. Merchant pointed out today. We have no idea how they keep their documents. We don't know who the custodians are. We don't know whether they're stored electronically. We don't know if, in this case, there's an IT department that has superior control over electronic information. We have no knowledge of that. You'd have to be somewhat sophisticated across the board to figure out how different agencies store their documents, to be in a position to cross-examine, in his words, follow up about things that we may not even know about. I think the 44 pages is very instructive, Your Honor. He was very cagey about that, and he was cagey for a reason. They altered the documents. There's no other way to put it. And
to give the benefit of the doubt, I think it may still be problematic, because even if the court doesn't assume that it was intended to obfuscate anything, the holder of the record can't have it both ways and say, I'm not required to create a document that does not exist in order to respond to you, but then in responding to you, create a document. That those two things can't coexist. I'm not as willing as you are to assume that it was intentionally done to obfuscate, but it is still problematic.
right, and exactly, Your Honor, because I think, he hemmed and hawed about that considerably when Ms. Merchant was questioning him about this. And he could have easily just said on the stand, yeah, that was a compilation that she put together and she took stuff out. He could have said that, but he spent 15 to 20 minutes arguing with her about whether it was a compilation or whether information was actually missing from the document initially. And then finally he conceded, yeah, there's stuff missing. And then he, as an open records officer, we asked him specifically, what's your obligation under the Open Records Act to produce a true copy of the document? And he wouldn't answer it. He said, for some reason, he just didn't know. And then eventually he conceded, well, yes, I do have to produce copies. But my larger point, Your Honor, I think is the way he testified is very important, because I think it establishes the mental mindset they had when he responded to these requests. And so I think the reason why that's important, I know Your Honor doesn't want to get into the machinations of the intent, and I totally understand that. But the reason why it's important is because it colors his testimony about these excuses. Because if he can't even tell the court in candor why that document is not an original document and won't concede it's an original document, that's the thing. That's the personification of this problem and why we're here today. So the final excuse that I noted was they were just too busy to comply. That's not a defense to an open records request. It's just not. It's certainly not a defense to an open records lawsuit. They have to find a way to operate within the confines of the law. There's no exception in the statute that says I get a pass because I'm a larger county, I'm a larger agency, I have more employees, or I have more requests. That doesn't carry the day. So that argument falls flat, Your Honor. So, and I'll save the linkage to the legal standard for later, but I think and I'll be candid with the court, there's been talk of why we didn't call all these witnesses. We subpoenaed everybody under the sun. We called blah, blah. We intended to call those folks. First, they filed motions to quash everybody. They did not want us to talk to those folks or did not think we needed to as an initial matter. But two, once Mr. Bond took the stand, I looked at Ms. Merchant and said, I don't think we need anybody else. I think he has just made our case for us because of how he's testified. So that's why we didn't bring a laundry list of folks in here, because it was unnecessary. I think the court has plenty, based on his own testimony, to find that we have overcome a directed verdict. Well, on a final point, Your Honor, before we get into the issues in closing, is this issue of vexatious. Just briefly, and I think if we go back to the number one thing he kept saying, he said, I'm not going to reach out and talk to you. Communication has been taken out. When he does that, and he does it only for Ms. Merchant, he's designed the process to make it more harassing, to make it more annoying, to make it impossible without further follow-up and constant follow-up by Ms. Merchant to get the issue resolved as it's supposed to be, more informally. He forced our hand. There's no doubt about that. We would not be here and we would not have filed a lawsuit had he just picked up the phone and tried in good faith to comply. So the standard is whether or not that's designed to be harassing and annoying. And I think if you looked at his testimony when he was responding to Ms. Merchant's questions, I don't think a single soul listening to him could disagree that he was trying to be harassing and annoying to Ms. Merchant while on the stand. And he actually made it very personal. And I think the fact that he took it very personal and that it was very much a Ashley Merchant issue is what colored the responses by his agency and by him. I think this, and we've seen it today with Miss Lobby coming in here and arguing things that just aren't relevant at all to the legal inquiry. And the reason for that is they have marching orders. Whether they're appropriate or not in the context of open records is not our fight. It honestly isn't. It's, did they give us the documents when they were supposed to? Do they have an excuse for not giving us the documents when they were supposed to? And if they have an excuse, is it justified under the law? And we think we've shown through Mr. Bond and through the evidence that we more than satisfy directed verdicts. We'd ask Your Honor to deny the motion. And on just a separate issue, because I don't think it was addressed, we got this motion, as I mentioned, just before Your Honor took the bench, and it asked you, Honor, to sanction us. I'm not going to cross that bridge because you're not crossing that bridge yet. But I also think that that's important for understanding why they have attempted to put up a smokescreen and just avoid the real issue here, which is, did they comply with the statute? They will do everything under the sun to divert Your Honor's attention. I know you're smart enough to not let that work, but that's what they're doing. They're just throwing up a smokescreen, hoping that you'll be so overwhelmed with the idea that we might actually ask for documents related to a criminal case that you're going to be blinded to the real issue here, which is, did they comply under the law? And we think that they did not.
Thank you. So, Ms. Alabi, it's technically your DV motion if you'd like a brief rebuttal.
Just briefly, Your Honor. Judge, the counsel's his last remark, certainly this court would not be overwhelmed by a mere motion. This is something that is done in the regular course of any litigation. It is appropriate in fact, in procedure, and in substance. This court has heard the testimony. There was a lot of discussion about the testimony of Mr. Bond, how he testified, what he testified to. Some of this, as the court has directed, counsel will be reserved for closing arguments, but specifically with regard to Mr. Bond just picking up the phone and calling the plaintiffs, the Open Records Act does not require that procedure. That is not something that the state or any agency is required to do.
I agree it doesn't require that procedure, but Mr. Bond testified that his typical handling of Open Records Act requests that he didn't understand or for which he needed more clarification were to call the requesting party and ask for that clarification. And then he testified that he would not speak on the phone to Ms. Merchant and did not extend to her the same courtesy, which I acknowledge it was a courtesy, not a requirement, but that he did not extend that courtesy to her while he did extend it to other Open Records Act requesters.
And that is in compliance with the law. We do not have to extend that to those individuals that we do not extend it to. That is an extra, it's a professional courtesy. It is not a requirement. The law does not direct us or mandate us to take that particular step or to take that action. It additionally does not mandate us to do that with someone who has not been candid with the court in their filings and or with other testimony regarding the same Open Records Acts. So in this motion that was filed to direct the judgment, there is a section, and I will do.
Ms. Alabi, you have said several times that you didn't believe Ms. Merchant or the Merchant law firm, who's the actual named plaintiff, was being candid that they were lacking in candor to the court in their requests. What is it that you think they failed to disclose to me? Where do you think they exercised a lack of candor?
Yes, Your Honor. So specifically, we, as I stated to the court earlier, we have a number of individuals that reach out to either the county or our office asking for certain documents. We have some folks that have, prior to plaintiff's request, asked for almost mirrored exactly the same thing that the plaintiffs have. We actually included that within our motion, along with, I believe it's Exhibit C, that goes through what those documents are. Some of them are in regard to critical mention. Some of them are in regard to what's the subject of this litigation. And so we see these mirrored requests that have come in. Mm-hmm. You know, I have been very careful with my words on what the evidence shows with regard to what has been filed into the record, what the evidence does show this honorable court. And it does appear as if the plaintiffs are, which is my understanding as to why Mr. Bowman asked Ms. Merchant when she was on the stand about whether or not she was working with other individuals, because the information that we have and now the court has based on the filing is that that information was already either mentioned or provided to the plaintiffs. And so,
Okay, so hang on. So I think I'm following. I understand now what you're saying is that you think Ms. Merchant was not being candid with the court because the documents that she was asking for, that she instituted this lawsuit to obtain, she already had from somewhere else. Is that, or knew that they already, like somebody else already had them? Is that it?
yes, Your Honor. Now, I want to be very clear because unlike the plaintiffs, I'm not going to assign, something to someone that I don't have 100% facts of. As I've drafted in my motion, we do have reason to believe that the plaintiff is acting in concert with other individuals requesting the same information, the same documents,
But
and
again,
having those
Ms. Allaby,
provided.
this is what I keep pushing back on. Why is that wrong? Tell me where in the Open Records Act statutory structure it says that you may not ask for records in concert with or on behalf of, or that you may not ask for documents that are otherwise Open Records Act requests that you already have. I mean, maybe that goes to the issue of substantial justification, but you're saying it as if they would be prohibited from asking for it. And that's where I'm not quite following.
I'm not saying it as if they are prohibited from asking. Again, people ask for stuff from us all the time. What I'm saying is when we as attorneys file complaints before this court and make allegations and talk about what we do have and what we do not have, as is the subject of this open records lawsuit, we have to be very careful about what we put in those filings.
Okay, well, to be clear, unless you're going to point me to a paragraph, right? I'm not aware of any allegation where Ms. Merchant said, I don't have. Ms. Merchant said in her complaint, I requested and was not given by the DA's office. That's different than saying I don't have those documents in my possession. That's not the same.
Your Honor, respectfully, we heard a lot of testimony and questioning of Mr. Bond, and in that questioning was a lot of testimony on behalf of Ms. Merchant. There was a lot of comments that were made. There was a lot of things that were discussed here, and I know she was not a sworn witness, but things were said with regard to those documents. Specifically, an individual was named concerning documents that were received in regard to the critical mention.
Except that questions asked by the witnesses are not evidence, and they're not anything that I considered except when Ms. Merchant took the stand. So my question is, are you alleging that in the complaint, she asserted that she asked for a document and didn't actually have it, right? Because that might be an issue of a lack of candor, although it's questionably relevant because, again, I'm not aware of any requirement that said, I mean, yes, it all goes to substantial justification, but that's what I'm struggling with is I am able to essentially ignore Ms. Merchant's questions because when she was questioning Mr. Bond, she was acting as a lawyer and her questions aren't evidence. So unless you're going to point me to somewhere that she testified or a representation or statement that she made in the complaint that is untrue, that lacked candor, then let's put a pin in that and move on, okay?
I understand, Your Honor. We have outlined in this motion the instances in which the plaintiff has lacked candor that goes to the substantial justification. We have outlined previous testimony before our Georgia State Senate with regard to this very lawsuit, this open records lawsuit that is before Your Honor.
Is not in evidence in this case.
Part of the filing at this point. And
Right.
so,
But this is an evidentiary trial, and am I aware of the fact that Ms. Merchant testified before a state Senate committee? Yes, because I think I saw the fact of that testimony on the news. Do I know what her testimony was? No. Do I have any knowledge of what she said about this case or any other case? No. And it's not in the record, right? That is not evidence before me other than that I am generally aware that Ms. Merchant testified in front of a state Senate committee about this Open Records Act or about her ongoing issues with the DA.
it is now, I'm sorry.
Go ahead.
Yeah, it is now part of a filing that is in the record. And so I wanted to bring that to the court's attention, that is the reason that one of the reasons that I come before Your Honor making this argument and specifically reference those instances. Now, I understand the court's position with regard to streamlining this particular argument with regard to directed judgment, because that's the portion that we're at right now. Okay, so we have outlined all of that within the motion, but this is certainly just back to the point of not what a common practice might be within an office and what the law requires. And there is no making of a new law because that is a practice within the office. I think it is the right of any state agency, the district attorney, the district attorney's office, to determine what is the most appropriate course of conduct to respond to anything that we receive within the office, so long as we are compliant with the law. And that is what we did here. Mr. Bond testified to the responses that he gave within a timely manner. We did send a number of letters, and this will be more outlined during the closing portion of this case, but we did respond with letters of inquiry, letters of, hey, we will get this information to you within a certain time frame. But the Open Records Act does not require that we be perfect in how we respond. It requires that we do in fact respond, and that is what took place here. Picking up the phone is not necessarily appropriate in certain situations. And in this situation, what was most prudent, what was most appropriate was to make sure that we documented and sent the requesters information concerning the individual requests, that we exercise diligence in providing the answers to those requests, and that we did provide at every turn in this case responsive documents that responded to the request. If there was an exception, we noted what that exception was and provided that to the requesters. And we exercised diligence in making sure that we responded in a timely manner. Plaintiff talked a little bit about the cyber attack and not knowing whether or not who keeps certain records, but I think that we are comfortable as practitioners to say we know that the IT department handles information technology. That would be very different than what the district attorney's office would do, that they would have a certain expertise in keeping digital records. I don't know.
I think we should probably put that off to the side, because that is one issue, one aspect that troubles me about all of this, which is that the county attorney's office has taken the position that Fulton County was never a proper party here because no requests were made to it. But yet now the line of questioning I'm hearing is that apparently Fulton County's IT department is entirely separate and somehow has authority, which I highly doubt, to go into the district attorney's office's emails and decide what gets responded to on a Public Records Act request. I feel like we should just I don't think we should go down that road right now.
Understood. I don't know that that's how that works either.
Right.
But I say that to say that these are separate entities that have separate information, right? So there are going to be numerous instances where the district attorney does not have what the requester is seeking. And as we have heard now through testimony, certain information was provided by information technology. Certain information was provided by our office. We, again, complied with the request. We did communicate, though not by telephone. We did communicate through the portal, through written documentation, through letters concerning each and every request that was made to the plaintiff.
But what about the timeliness, right? Because part of this is not just that the documents were produced, right? So let's say I accept your representation that ultimately all the documents that were requested have been produced. Mm-hmm. One of the requirements is that it be done timely, and it doesn't seem to be really at issue that these documents weren't provided timely. And theoretically, I'm sure that the merchant law firm, part of their argument about why they're entitled to at least some of the expenses is because the responses were not provided timely in compliance with the statute, and they had to expend fees to get the documents some, months later.
So, Judge, the Open Records Act requires that we respond within those 3 days. We might not have those records within those 3 days, but we did provide a response. We did ask for the plaintiff's patience in compiling, not compiling, but in gathering those documents, providing those documents. And so the Open Records Act does not require that within 3 days, we just magically wave a wand and here are these documents. Responding, which we have done, to the requester, giving them a time frame in which we anticipate being able to provide those records is exactly what happened here. It's exactly what Mr. Bond testified to. Specifically in regard to the cyber attack, where we did not have access to records. The whole county was down for some times, and forgive me, Your Honor, I don't remember the time frame in which that was, but there was a time frame in which we did not have access to any of those things.
Mid-January into February, I think.
Immediately after this lawsuit was filed, and it was one of those situations where obviously we have no control over a cyber attack. We are exercising diligence and doing everything that we can to communicate that to not just plaintiff, but to anyone else with regard to any cases that we might have within the office, within any, motions that might need to be filed. That was a countywide situation that we had to address. So was there a delay? Absolutely. Were we justified in that delay? Absolutely. Did we let them know that there was a delay? Absolutely. And so the Open Records Act does not require that they receive those documents in the 3 days. We just have to let them know what's going on. There are going to be times in which there is clarification needed. But what we cannot do is have a request for a particular thing and then turn around and try to expand that scope, to turn around and say, well, you didn't get it to me within the 3 days, even though the law does not require receipt. It does require communication. It does not require receipt. And we have given them that very thing. And that's why I keep harping back to they have the documents, because they did. There was a lot of questioning back and forth with the 44 pages, the 100 and whatever pages when Mr. Bond testified. There was a lot of questions that were asked and testimony that was provided that other individuals from our office responded to the plaintiffs, said, hey, this is give us 10 days in order to get this. There was a lot of testimony concerning that, which is exactly on point with what the statute requires of us, is exactly on point with what we did. And that is why we are asking for this court to make a ruling in favor of the defendants.
Thank you.
Thank you, Judge.
Okay, so on the motion for directed verdict, the standard for a motion for directed verdict is that a directed verdict should be granted when there is no conflict in the evidence as to any material issue, and the evidence introduced with all reasonable deductions demands a particular verdict. And in determining whether there's any conflict in the evidence has to be construed in favor of the non-moving party. The defendants have not satisfied their obligation, or excuse me, their burden to be entitled to a directed verdict, and so that motion is denied. Now, I believe the evidence is closed because in addition to hearing the DV, my understanding was from the county that they did not intend to call any witnesses. Is that correct, Mr. Bowman?
That's correct, Your Honor.
Okay. So that means where we are is on argument regarding whether or not a violation of the Open Records Act occurred. And if it did, was, I guess, was either party not substantially justified in either their request or in the compliance with it. Mr. Merchant, do you want to, well, technically, since we're adding procedure back and forth, do you want to reserve and waive, or do you want to open and close?
Well, I want to make it easy for Your Honor.
Okay.
I think in large part, I did lay out the legal basis for finding of liability against the defendant. So I don't need to belabor the point. If Your Honor has specific questions about the liability or the damages issues, I'm happy to raise them. I just want to, I don't want to reserve. I want to talk now.
Okay.
If that wasn't obvious.
It was. Go ahead.
So I do want to correct one thing. And I think fundamentally this may be where the rubber hits the road in terms of why they think just sending a letter is sufficient. That is not the law, Your Honor. We're hearing for the first time today from a lawyer who has not represented the county until the district attorney's office until today, at least as far as we're concerned, that all they have to do is send us a letter that we're trying in good faith. That is not what the law says. The Wallace case specifically deals with the timing issue.
That's the microphone.
In that case, Your Honor, I'm not talking in generalities like others. That case says, we conclude that if a person or agency having custody of the records fails to affirmatively respond to an open records request within 3 business days by notifying the requester of the determination as to whether access will be granted. That means the agency under the Wallace decision and under the Act has to make a preliminary review of the documents and make a determination about whether they are going to produce documents or not. And then the discussion about timing can occur. But until that happens, and unless it happens, they are in violation of the Act. So there's been no argument until today that they were ever responded to in a timely manner. And there was this discussion of Mr. Bond's good faith that he was trying to communicate with Ms. Merchant. If this had been a one-off situation, Your Honor, where one request we had some issues with, potentially we could see that it was an innocent mistake or that they really were trying. This is a pattern. This was a pattern and continues to be a pattern with this office as it relates to Ms. Merchant. We don't know necessarily how they react to other members of the public, but we know exactly how they react to Ms. Merchant, and it's to obfuscate and to harass her. So the other thing I wanted to point out, Your Honor, in terms of closing for the liability issues is this brief that they filed today, I think is instructive for a couple reasons. And the most important is that the lawyers who have represented the district attorney's office until today did not sign off on it. I think that's important. And I'm not here to highlight the divisions between the county attorney's office and Ms. Levy. That's not what I'm here for. I'm here
Let's not go too far down that road, except to note that these are civil litigation practitioners, and they perhaps had different approaches, and we're just going to leave it at that, as would Ms. Allaby, who is and of course the DA, who is a criminal practitioner.
That's
so let's just leave it there.
That was going to be my exact point, that this is a civil case, and we didn't get it until today. And I think it was the document itself, I think, was done on purpose to sucker punch Ms. Merchant at the 11th hour. They put it into the record, and then they came here with a different person to argue facts that are not in evidence, as Your Honor has correctly pointed out. So I'm making an oral motion now to strike the entire brief from the record, since much of it contains rhetoric and evidence that's not been admitted. As far as damages, Your Honor, I think the evidence that's in the record is clear about our fees and our expenses. And I'll be the first one to tell you that we do not like doing this. This is not, we don't wake up in the morning and say, let's go file an open records lawsuit and let's spend thousands of hours of attorney time and thousands of dollars out of the bank account in the hope that maybe they'll comply. That's not how we do this. We did this because we had to. And because of the remedies available to us under the law are limited to what's in the statute, we had to file the lawsuit. There's no other remedy. So we previously talked about injunctive relief. I don't need to discuss that issue any further, Your Honor. Our point on that's clear. But I do want to end on sort of a policy-related argument, in that I think it's not just because of the visibility of this case in the local news or other places. I think this case is important because if this is the type of conduct that is going to be permitted, we're all in trouble. Not only is it going to make it difficult for the average citizen to get documents from public agencies, it's going to be cost prohibitive. We did not jack the costs up in this case. We did not jack the time up in this case. We did what we had to do to get it to the end as expeditiously as possible. And you saw that. We eliminated the number of witnesses that we could have called to pile on top. We didn't do that. We got to the finish line as quickly as we could. And I think if this case doesn't justify a finding of non-compliance and lacked substantial justification, I can't imagine a different case that would, Your Honor. This is about as blatant as it gets, and Mr. Bond made it easy for you. So we'd ask that Your Honor enter a verdict in our favor and against the defendants and award us our fees and expenses as laid out in the exhibits with the court.
Thank you.
Thank you, Your Honor.
Mr. Bowman, Ms. Monroe, who will I hear from? Okay.
Good afternoon, Your Honor. So after 3 days of testimony on this matter, it's clear now more than ever that the plaintiff has failed to introduce evidence sufficient to demonstrate that the DA or the DA's office acted without substantial justification or negligently in complying with the Open Records Act. The testimony of Dexter Brom establishes that not only did the DA's office comply with the act, but that there was substantial justification for any non-compliance. Now, the act provides a definition for lack of substantial justification, which is outlined by my adversary, and it's defined as substantially frivolous, substantially groundless, or substantially vexatious. In response to the plaintiff's 13 open records requests that were voluminous, overtly broad, and convoluted, the DA's office provided approximately 950 pages of records free of charge to the plaintiff.
Well, in fact, let's be clear though, you might have actually given them 950 pieces of paper, but some of them were the same documents in different batches, right? Because so like initially they got 47 pages, later they got 195 pages, which included that 47 pages. So if you're adding them all together, you might get to 950, but I'm not sure it's 950 separate documents.
According to GovQA, according to how the requests were submitted and how they were responded to, there were a total of approximately 950 pages that were provided to the plaintiff before this action even commenced, free of charge to the plaintiff.
Okay.
Okay, so before this action even began. So these documents were provided by the DA's office in the spirit of good faith, transparency, and open government. In light of the DA's office primary statutory focus, which is to prosecute criminal cases, the testimony of Mr. Bond demonstrates that the district attorney's office responded reasonably and prudently. The requested records that were in the custody of the DA's office were provided to the plaintiff, and the DA's office can only provide what they have. Now, there's been ongoing rhetoric by the plaintiff has been since the beginning of this case, which is that, albeit a very erroneous position, is that, well, the documents exist, so we should have it. Just because the documents exist somewhere by some other source doesn't mean that the DA's office has this document. That doesn't mean that they have custody of this document to provide it to the plaintiff.
I understand that, Ms. Monroe, but I think that the fact that the document exists is relevant for two considerations here. One is the fact that it exists undercuts any argument that the DA doesn't have it, because oftentimes it's a document that was created by the DA's office, right? So why does it exist and is in the possession of some third party, right? If it wasn't also in possession of at some point in existence of the DA's office, number one. And number two, to some extent, if it does exist, yes, it means the DA must have it because of records retention obligations that government entities have in terms of not destroying documents to avoid the effect or application of the Open Records Act.
Well, that's not what the Act says. The Act doesn't give a request of the right for information that or documents that this agency should have. It has to be documentation that's in their actual possession. Because in that case, if you do that,
Ms. Monroe, that can't be right, because by that logic, that would affirmatively provide an incentive to government agencies to destroy documents in violation of the Retention Act so that they could honestly say, I don't have that document, so you can't make me produce it. That doesn't make sense.
That's a violation under a completely separate act, not the Open Records Act, the Retention Act. Yes, but not the Open Records Act. And which is why we're here. I mean, that goes with the presumption that documents can't get lost or documents can't get misplaced. I'm not saying that's what happened here, but things happen, especially in departments of this nature, departments that have several duties and functions in place. So to say that because they should have the document and they did not provide the document, knowing that it has been communicated that they do not have the document, is not what the Open Records Act was designed for.
Well, I think part of the issue here is whether or not it appears that there's a routine process or a good faith effort to locate the documents. And that part of the problem here is that if it seemed as if there were a routine process that were always followed, or it seemed as if the individual had engaged in a good faith effort to identify and respond, then perhaps accepting the representation that those documents didn't exist, right, would be a little easier. But here we have an individual whose job it is to respond to Open Records Act requests, Mr. Bond, who, I mean, there's no other way to say it. He seemed openly hostile to Ms. Merchant, and not just because she was asking him questions in this courtroom, right, which is justified. And, you know, I understand people don't like to be questioned, but he seemed openly hostile to her and to the idea that she would ask for things and that he was obligated to provide them or communicate with her. And that is what concerns me here in terms of accepting the representation that a good faith effort was made to locate the documents that she requested.
And I'll go into the good faith efforts made by the DA's office as it pertains to the particular things that were requested. But to the court's point about Mr. Bond's testimony, the court can't ignore the fact that, you know, Ms. Merchant baited, there was a lot of baiting that was taking place with the type of questioning that was conducted by Ms. Merchant. So
yes, and I would expect highly educated professionals to be able to conduct themselves in a way without responding to that baiting. Just saying. Go ahead.
Well, the questioning came from a highly educated or alleged to be professional, and so that needs to be highlighted as well. That can't be ignored. I just need a moment, please, to regroup myself. Thank you. In the case cited by Ms. Allaby Felker, the Georgia Supreme Court clearly states that through reading of the Open Records Act, it makes clear that the legislator did not intend for the custodian of public records to comb through his files or her files in search for documents sought by the public citizen. To the contrary, all of this was required. All that is required of the public record custodian is that he or she provide reasonable access to those files that are sought. And I'm going to go address these things one by one. And I want to highlight to the court that this case has been a moving target from the very beginning. We started off with a complaint that was filed against the district attorney's office. We reached out to the plaintiffs to inform them that they are not district attorney's office is not an entity capable of being sued. Upon that, there was some brief response about maybe we should file an action against Fulton County. I said, why would you do that? You never submitted a request to Fulton County. I then had to file a motion to dismiss. That motion was argued. The court granted the plaintiff an opportunity to add whoever they wanted to this action, whoever they deemed would be the appropriate party to this action. They then filed a motion against Fulton County, knowing that Fulton County would never receive a single request from the plaintiff.
Well, so I've already made this comment to Ms. Allaby. I denied the motion to dismiss Fulton County because based on the portal and the fact that and Ms. Merchant testified today, some of her requests were not directed to the district attorney's office pull down. They were directed to personnel, which theoretically might be the county. They were directed to IT, which might be the county. And while I personally absolutely assume that the district attorney's office has the ability to control what is produced, right? Because those are things that are associated with the operation of the district attorney's office. It does sound very much like some of those requests were submitted to the county and the county IT department or the county personnel office or the county finance office responded. So I don't,
Right, but those are not the requests that were outstanding in this case. to
well, I
bring a
understand, but
lawsuit. So
I'm just
we're-
saying, Ms. Monroe, you're not gonna change the outcome here, right? You're not gonna persuade me on this issue of reminding me what the procedural happening of the case was, because I'm the one that ordered the procedural happening of the case, right? I mean, I know that the county takes issue, not the county. I know that the defendants take issue with the procedure that I use to allow all 4 of these defendants to go forward. But you can file an appeal at the appropriate time if you don't like any ruling that I enter, right? I've ruled on the motion to dismiss. The county is no longer a party to the action. Their requests to the county are no longer at issue in the case. The only entities that are a party to this case are Madam Fani Willis in her official capacity as the district attorney and the Fulton County District Attorney's Office, which I have said legally, until told otherwise by the Supreme Court potentially tomorrow, is an entity that is subject to the requirements of the Open Records Act because it's an agency or an office, even if it is not an entity that is normally capable of being sued. So let's put that procedure away and move on, unless you want to tell me that you think it's specifically relevant to a particular issue as to the Open Records Act.
As to the Open Records Act, no, but as to attorney's fees, yes.
Okay, and that's fair enough. I understand why you would take issue with that.
And I was just trying to take I'm sorry to cut you off, Your Honor. I was just trying to take a chronological approach to my, to this closing, but I understand I'll address that later. So right now I'm only addressing the Open Records Act violation, not attorney's fees. Okay.
Okay.
All right, so I'll just shoot straight to the actual request. So from when we started this case, yes, the complaint listed about approximately 13 requests, okay? However, based on how the case was moving and based on the legal arguments and the factual arguments made by the plaintiff, the only issue that was talked about, argued, pursued, demanded were the critical mention records. The other requests didn't even become an issue until after plaintiff, i.e. Ashley Merchant, discovered that there was a special program needed to open up attachments, which granted were made available to her after documents were subpoenaed by Fulton County and, IT Fulton County and provided by IT Fulton County, that we directed her to, hey, you need a PDF, Acrobat Adobe program in order to access these attachments. When she was able to access those attachments, great, thank you for these documents. I didn't know that I needed this. I didn't know I needed this special program in order to access this, these attachments.
A fact that Dexter Bond could have told her if he'd picked up the phone and called her.
Well, here's the thing about that. These documents weren't provided by Dexter Bond. These documents were provided by Fulton County IT. Okay. Now, I don't work in the technological department. I don't know
None of us
why.
are qualified to talk about IT, that's for
Okay,
sure.
so I don't know what the issue was, particularly about the attachments, but based on my assessment of the records, the documents that were originally provided by the DA's office showed that there was an attachment on the email. They would look like a hyperlink, but for some reason you couldn't click on it. Every time you try to click on it, it would not open up a document. And I'm assuming that's the same issue that Mrs. Merchant ran into. Fast forward, we're in litigation, subpoenas are issued, not just one to Fulton County, a total of 18 subpoenas that were issued in this whole entire case, 18. The critical mention subpoena that were issued back in August, I think those were about 6. Don't quote me, maybe 12. Hold on, I'll tell you right now. There were 16 subpoenas that were issued back in August, okay? All for critical mention records. There were no subpoenas for a list of hirees. There were no subpoenas for forfeiture reports. There were no subpoenas for I forget the other, branding, promotional materials, NDAs, none of that. Why? Why not? Why not do that? Right? Because it wasn't about that. It was about the critical mention records. Now they're provided, right, by IT. Granted, we have business record certifications signed by several members from the DA's office saying, hey, we got these records from IT. We didn't provide these records. We didn't have custody of these records, but IT did. And we reached out to IT, and this is what was provided by IT. We had someone, and I'll save this issue for the attorney's fees regarding all the other members that were subpoenaed in this matter to speak to the point of expansive litigation. But nonetheless, granted, there were 44 pages of documents that were provided originally before this action commenced, and there was close to 400 documents that were provided as a result of the subpoenas. But the point is, that point is still irrelevant because the subpoenas did not mirror the actual open records request. The open records request, the original open records request as it pertains to the critical mention documents were very general. They did not provide any specific emails to be searched. Do you know how many employees work for the DA's office? I don't even know that number. Right. However, the request demanded
from the county responded to Ms. Merchant, to my knowledge, in this record and said, we don't know what you're asking for. Please clarify.
I'll tell you why not. Because the subpoena, are you talking about the request pursuant to the subpoenas?
No, I mean, it's clear that the county attorney and everybody all got together and figured out how to respond to the subpoenas.
Mm-hmm.
I'm talking about the Open Records Act. I thought I understood you to be
Yes,
saying.
I understand what you're saying.
Yeah.
So you're right. They did not reach out and say, hey, we need more detail. No, why? They didn't have to because Ms. Merchant didn't ask for that. You know what she asked for? Hey, I need those reports. I need those attachments. I don't have those attachments. She didn't ask for certain emails to be searched. She didn't ask for certain search terms to be searched. The point that I'm trying to make to the court is it would be unfair to compare the request from the underlying open records critical mention request to the subpoenas because they're two different requests.
I have no intention of doing that.
Okay.
My job in an Open Records Act request is to look at the request that was made, to determine and assess if it was clear and understandable, and then to look at the responding party, assuming that they're public records that are subject to the act, and determine if the government entity made a good faith effort to respond or was substantially justified in not responding. So to me, the subpoenas are, I agree with you, irrelevant, the responses to the subpoenas, except to the extent that, as I understand Ms. Merchant's argument about what she got in response to the subpoenas is the fact that those documents existed, they would have also been responsive to her Open Records Act request. And the fact that they were produced in response to a subpoena means they should have been produced in response to the Open Records Act request.
And I disagree with that point. Here's why. Because those documents that were produced, those attachments, those analytical graphs, those reports that she was seeking, right, in her follow-up communications to the DA's office, they were not provided by the DA's office thereafter pursuant to the subpoena. They were provided by IT's office, the IT office. So why that is, I do not know. It could be a technological issue, a technological mishap. I don't know. But the documents were not provided as a result of it being in the custody of the DA's office. And that's a distinction that I want the court to understand.
So this gets us right back into this whole, was Fulton County a proper party or not a proper party? Because this is where I don't think that the DA's office can have it both ways, right? If these are emails that were called by the IT department of Fulton County from email addresses that end with fultoncountyga.gov, right? And they are the email address of Kevin Armstrong or the email address of Fani Willis or the email address of whomever, other people's names that were mentioned in here, Jeff DeSantis. then are those not documents that belong to the district attorney's office? And how are those emails not in the district attorney's possession, given that they're her emails? And if they're not, then isn't Fulton County a proper party and should have remained in the lawsuit because they're in their possession, which again, can't be the answer, because there's no way that the district attorney's office doesn't have the ability to say, don't you dare produce my emails, Fulton County.
I think what the issue is that it's not, so Fulton County, let's just be clear, is not the proper party here, just by way of using the, and I understand the court ruled the way that it ruled. I'm not trying to re-argue that.
Right, I understand.
But the way that it works is that a request is submitted to either Fulton County, right, by way of its respective departments that fall under Fulton County, i.e. IT being one of them, or it's made to a department that is not under Fulton County. The DA's office is not a
The Fulton County DA's office. Go ahead.
Yes. The Fulton County DA's office, it's not a department under Fulton County. The DA's office is the DA of the Judicial Circuit,
So
of the Atlanta Judicial Circuit.
So your position is that the district attorney's office is not in possession of its emails?
No, that's not what I'm saying. What I'm saying is that they're very separate and apart from Fulton County is what I'm saying. So that's why it's very important when requests are submitted, right? And maybe there's work that needs to be done in clarifying that distinction, because Fulton County is the only county under the Atlanta Judicial Circuit. Get what I'm saying? So oftentimes,
Fulton County and Atlanta.
Oftentimes those things get blurred. Those lines get blurred. Oftentimes, because we're the only county. But the reality is that they're very separate. The DA is a state elected official. She does not fall under Fulton County. She's not a Fulton County employee.
But somehow Fulton County has possession of her emails.
And this is...
I'm sorry, I'm not going to let this go. That does not make any sense.
And I don't have the answer to that, Your Honor. Unfortunately, I don't. But because they have access to her emails, does it somehow merge the two?
I'm not saying that it merges the two. I'm saying that if Fulton County IT was able to pull those emails, then why wasn't the district attorney's office, when it received a request to which those emails would have been responsive, able to produce them? And I think your answer is, well, they weren't in possession of them, which means Fulton County is in possession of them, and that can't be right. That doesn't make sense.
Well, Your Honor, I unfortunately, I don't have a response to that. I'm pretty sure there is some sort of technological response to that I do not have information to, but I do not. And
right, but I'm not,
and according
I'm not talking about technology right now. What I'm talking about is Dexter Bond, right? If a request, and I'm speaking completely hypothetically, I'm not intending to tie it to the specific request here, but if a request was made for email communication about a particular thing, right? Dexter Bond has the ability to search his own emails and figure out if he has any emails. And the fact that an IT search could be done by Fulton County and locate such emails is a concerning indicator that no such search was made by the DA's office when requested. That's what I'm trying to, it's not a technology issue.
I mean, I hear what you're saying, but I do think there's some element of technology to it that we may not be considering here. I'll speak from a personal standpoint. When I've gone back to search my emails for, let's say, things that happened back 3-4 years ago, I can't access those emails. Why? Because they've been archived. I may not know how to do that, but you have an IT department that will specialize in telling you how to do that. Or let's say, for example, if I'm looking for a specific attachment, it is no longer available for some odd reason. I don't know.
Right.
But
let me just, I want to move on from this because there's no point in about us disagreeing with each other. But I will say that the reason I keep coming back to it is given the requirements under the Open Records Act for designated custodians and the fact that Mr. Bond is the designated custodian, et cetera, I think there does need to be an answer, right? Because for you to say that the DA's office wasn't in possession of these emails that ultimately ended up being responsive, but IT was, and that's how they got produced, then that means that the Fulton County District Attorney's Office is taking the position that Dexter Bond on behalf of the elected district attorney is not the records custodian of their own emails. And the reason I say that is physically being able to access it versus having the legal charge to be the custodian of those official documents, two different things. And the reason to me that's two different things is even if Mr. Bond, and I think I heard Mr. Bond testify about some particular issue, well, where there's the DA's IT and then there's county IT. If he's the records custodian of those records, then he would potentially be obligated to reach out to Fulton County's IT and say, search for these documents and get them for me because I need them. They're mine, but you have the ability to find them.
And he testified to that. He did testify to that. He testified to his attempts to reach out to IT internally within the DA's office and externally, and to no avail. And I think that has a lot to do with the request itself. It's too general, it's too overly broad. It didn't provide specific emails like the subpoena did. The subpoena provided specific emails, almost like, I forget how many people, I think it was about 16 people in that list, who they subpoenaed people who used to work for the DA's office, people who currently work for the DA's office. There were subpoenas from someone from external affairs, IT. It was very, very detailed, provided timeframes, provided search terms, none of which existed in the underlying open records request. I just want to note that.
Well, but perhaps again, because nobody reached out to Ms. Merchant and said, we don't know what you're asking us for, help us understand.
I mean, so I think it's unfair to say that because when you have as many open record requests as you did in this case, right, to sit here and say, well, if the requester if the requester is only concerned about the reports, right, and that is the only follow-up issue, to now put the onus on the responder to make more inquiry about something that the requester is not even seeking. The requester had no issues with the actual emails that were provided. They just only expressed interest in getting the attachments.
My understanding of the obligation to respond is to assess the request, to figure out if you understand what's being requested. And if you don't understand what's being requested, my understanding is there is some obligation for you to clarify what is it that you're asking for. Because otherwise you risk not complying with the statute and it being demonstrated later that it was clear what was being asked for and you just didn't give it to me. And so I'm not sure I agree with you that the district attorney's office records custodian had no obligation to get clarification about what was being requested.
I mean, based on his testimony, I don't believe that the request was unclear.
You can't have it both ways. Either it was clear and he knew what to give her, or it was
I never said it was unclear though. I said that it was overly broad. So in comparison to the subpoena, now that we have the subpoena, right, that the plaintiffs are trying to tie in and merge together to say, hey, listen, they had the documents all along, we didn't provide it. Here you go. I think it's unfair all I'm saying is that I think it's very unfair to compare. If we're going to compare the two, they need to be the same. And in this case, they were not the same is what I'm saying. All right, so I'm just going to move on to the confidential agreements. Now, Dexter Bond did testify that originally when the request was presented, based on the communication between the request and the DA's office, it was the open records team for the DA's office understanding that they were seeking seeking NDAs regarding the media. Now, because that was their understanding at that point, in their January letter, the response was no responsive documents. It was not until after.
So I think the request said a copy of the NDA confidentiality agreement that employees are required to sign. I don't know that that's unclear. That was in the January 9th, 2024 letter.
So if you go to the actual request itself, it had more, there was more verbiage to that, but it
Well,
did, it did,
I think I remember Mr. Bond saying that there was some reference in this, like in the paragraph to the word media, so he thought that's what was being asked for,
Mhm.
but again, did not ask for clarification. Go ahead.
Okay, duly noted. So once we got onto this case as attorneys of record for the DA's office, we ran through the, so I just want to backtrack before we even move on to these NDAs. I'm sorry. So again, it's always been about the critical mention documents. Once they were able to access the PDFs, it now became about these other things, which were the NDAs, the list of hirees. Had we known that this was an issue from the very beginning, that this is what they were seeking from this lawsuit, and that these are the documents that were still outstanding, we would have worked very closely with our client to say, hey, listen, how could we be of support to you? Maybe there's something that you may have missed in their request, something that you may have not considered, to see if we can get the documents as quickly as possible, because the whole goal here is to mitigate litigation, right? We're not trying to have this long drawn out.
I think technically the whole goal is to provide public records to members of the public.
Yes, before getting here, absolutely. But now that we're here in litigation, right, is to provide that information, but to provide it in a swift manner, right? Not to wait until the end and say, here you go. As soon as I can get you this information, is as soon as I want to give it to you. As soon as I can get my hands on it, now that I know what the issue is, that's my role as the attorney. It's not to win this case, it's to make sure that they get the information, and they get the information as soon as possible.
To be clear, I don't have any question or doubt that you and Mr. Bowman, when you were involved in the case, endeavored to try and respond in good faith and fully to the extent that you were provided with information and documents to the subpoenas. I don't question that at all.
Okay.
But that's not really what the case is about. The case
Right.
is about.
I'm just getting into my next point, Your Honor. So once clarity was provided, those NDAs, he said, okay, as Mr. Bond testified, he understood what they were asking for. Then he said, yeah, well, this is something I can look into. And that's exactly what he did. And as soon as he did, he sent an email out to his employees to find out whether or not who signed, what teams were obligated to sign these NDAs, and what was provided back to him, we provided to the requester. As it pertains to all attorneys hired, the request regarding all attorneys hired by the DA and promotional materials and branding materials. Again, we are not, according to OCGA 518.71 subsection J, public officer or agency is not required to prepare any new reports. As the court may know, summaries, compilations, not in existence at the time of the request. Thus, the plaintiff cannot expect that the defendant to create documents in order to respond to these requests. And then, according to Dexter Bond's testimony, they didn't have a list of hirees, right? And so, because the plaintiff was of the impression that they should have it, again, we're back to this should or did.
Ms. Monroe, I have not so far accepted the invitation from Mr. And Ms. Merchant to order you to produce something that I agree with you probably doesn't exist in the exact form that it was requested, which is a list of lawyers and their dates of hire. But it strains credulity for the DA's office to say that it does not have a list of its employees. And so let's just put that aside and move on, because I had not up to this point, and do not intend, in terms of if it is still one of the outstanding injunctive relief items, to require the DA to create a list that it says does not exist in the exact form it exists. But again, if the records custodian had wanted to be agreeable, he could easily have said, well, of course we have a list of all the attorneys that work for us because we pay their bar dues and we do other things that require a list, like generate a really pretty booklet that promotes all the great work that our lawyers do, right? But we just don't have that list associated also with the date they were hired. That would have been a fair response. But instead, Mr. Bond said, we don't have that. And so I'm just saying, let's move on from that, because I'm not going to force you to create a document that doesn't exist, but I don't think that harping on that point necessarily persuades me. Okay.
All right, so and moving to the last request, dealing with forfeiture reports. According to Mr. Bond's testimony, he researched the matter. He provided a report that he had knowledge of based on his conversations with the clerk of the court and provided it to the plaintiff. The forfeiture report that the plaintiff was seeking, however, was very different from what she was looking for. And as illustrated by Mr. Bond's testimony, the report that she was actually looking for, he had no knowledge of. Although it had his signature, it was a signature that was not affixed by himself. It was a signature affixed by another member of the office. And, you know, according to his testimony, it wasn't a document that he had knowledge of, thus could not provide. It was his understanding that this report consisted of the document that he provided based on his research and based on his communication with the clerk of court. And those, in a reasonable opinion, were diligent efforts to get the information and to provide it to the plaintiff. And I'll reserve the remaining part of my closing regarding attorney's fees when the court permits. Thank you.
Mr. Merchant?
We have nothing for review.
Okay. Okay. My apologies, Ms. Monroe, because I feel like I was very confrontational with you, and it's not anything intended to reflect upon your presence here in the courtroom and your capabilities as a fine attorney. So I apologize if I was a little more confrontational than I really should have been. So my apologies. I think that what I have said several times, and I continue to struggle with, is that it appears to me that I've already said that I think either or both the Fulton County District Attorney's Office and Madam DA Fani Willis in her official capacity as the District Attorney of Fulton County are subject to the Open Records Act. And therefore, the response that would have been appropriate would by the records custodian, who in this case is Mr. Bond, would have been to recite some procedure that he follows or some process that he follows, which I didn't clearly hear in terms of when he receives a request. The impression that I got from hearing the testimony of Mr. Bond is that there are certain types of requests they get all the time, and they are used to responding to them, and they, you know, maybe closed criminal files, things like that, right? And that those are pretty standard. And I imagine that these requests were somewhat out of the ordinary for what the office requires or typically handles. But the fact, and this is where it really gets off the rails, that not only was Mr. Bond not able to testify to a particular process that he follows by requesting, you know, from IT to do searches, and more importantly, to follow up with certain people, but not Ms. Merchant, about what it was that was the nature of the request. Seems to me to indicate that there's something of a problem regarding the efforts of the records custodian of the Fulton County District Attorney's Office to in good faith comply. Now, having said all of that, here's what we are going to do. I am telling you right now where I am leaning and how I'm going to rule, assuming that tomorrow the Supreme Court does not say that the District Attorney's Office and the individual officially duly elected person is not subject to the Open Records Act. So it is not my intention to enter an order today, but I do want to tell you what my likely ruling will be, because I'm going to reserve the issue of attorney's fees, right, with in terms of damages that are sought. I believe, based on the evidence that I've seen, there is no dispute that the records that were sought, that the requests were clear, and that to the extent that the custodian did not understand what was being requested, it was the obligation of them to make a good faith effort to make sure they understood what was being provided or what was being requested. I do not believe that the records custodian engaged in a good faith effort to determine how to respond to the requests that were made. I also am unpersuaded by the idea, given the high profile nature of so much of what the district attorney's office does in Fulton County, the sheer volume of just media requests alone for public documents makes me question the idea that 13 requests from one individual was somehow overly burdensome. Because of that, it is my inclination to find that as to the NDAs, as to certain of the open matters, and that's the part I'm reserving, right? I have materials here from the merchants to make sure I understand what they believe, what matters are still open. It appears to me quite clear that the NDA issue is still open, right? And it may be that y'all can resolve that, but my issue really is that while I appreciate, Ms. Monroe, your assertion that the subpoenas, right, were the resolution of this problem and that they're not, that they asked for different things. I think having seen the subpoenas and comparing them to the Open Records Act requests, the reason they're different is two things. Number one, there were attorneys in the form of Mr. Bowman and Ms. Monroe who were in good faith trying to understand what was being requested and comply with the request. That was not the same in the Open Records Act request. And two, by the time those requests morphed into the subpoena that was served on Fulton County, Ms. Merchant had been educated about what it was she was asking for and how to ask for it more clearly, which again, could have all been accomplished had Mr. Bond not had the Ashley Merchant rule. And so all of that is to say this, what I'm going to ask for from the merchants is a proposed order that rules in favor, or proposed judgment, I guess it would be, that rules in favor of the merchant law firm in this action as to those specific items that were not timely produced. And here's where I want to focus. I'm going to focus on the fees issue, the expenses that were associated with their efforts to recover these amounts. And here's why. I've given the DA's office a real hard time. I would be remiss if I did not say that I'm quite certain that Ms. Merchant has been difficult and has potentially used these proceedings, right? Particularly the subpoena to Madam DA Willis individually to gain either media attention or positioning in the criminal case. While I'm certain that is true, as I challenged Ms. Allaby about a moment ago when she was speaking, my understanding of the Open Records Act request is while some of that argument may be relevant to whether or not Ms. Merchant or the firm was substantially justified in making these requests, at the end of the day, the relevant consideration is, are these public documents that the public is entitled to see? And was a request made and was a good faith effort made to comply with those requests? And because despite the fact that the DA's office may not like what Ms. Merchant may or may not do with those documents, that doesn't change the outcome. And so the reason I say all that is to say that I don't intend necessarily to award the entirety of the attorney's fees that were sought by the Merchant law firm. I expect that I will cull a good bit from it because I believe that some of it, particularly the subpoenas to all the various parties, when it took me 10 minutes into that first hearing to point out that I wasn't going to hear from any of those witnesses until it became absolutely necessary, because those witnesses were in possession of specific information that no one else was in possession of. And that's a fairly standard approach in civil law. And so I do think perhaps there was an expanding of the proceedings, but I'm not ruling on the motion that was urged today regarding sanctions and fees, but I will say that that still probably wouldn't rise to a basis for sanctions, because very quickly the merchant law firm got the testimony that it believed it needed to prove its case from one witness and then released the others from further requirements to testify, despite the fact that, you know, if it was really Ms. Merchant's intention to get media attention and hype this all up to the media, she could have continued to insist and get into an argument with the court and brief, et cetera, on this entitlement to examine Madam DA Willis. I will also say that I take exception to this argument that this entire characterization of Ms. Merchant, who again, I don't doubt that she has been, I'll stick with the word difficult because that's what I said before, right? That she is someone who is aggressive and difficult, can be difficult to deal with in litigation, whether it be civil or criminal. I understand that. But the district attorney's motion and the effort to characterize it as being in bad faith by hyping up all this media attention to harass the DA's office could have all been cut. All of that could have been cut away if Dexter Bond had picked up the phone and called John Merchant or Ashley Merchant and said, what are you trying to get? And then given the documents. Or engaged in a good faith effort that would reassure the requesting party that some good faith effort had been made to locate those documents, so that when the representation that no such documents existed or were in the possession of the custodian was made, it would be more credible. So all of that is what I'm going to do, assuming again that the Supreme Court doesn't wipe this all away tomorrow, is enter a judgment in favor of the merchant law firm regarding the failure to timely provide the documents that were requested, the ones that are still listed, the ones that are still outstanding, if there are any. It sounds like we've abandoned most of them except for perhaps the NDA in terms of injunctive relief. Mostly this is about failure to timely provide, and that will occasion an award of attorney's fees in favor of the merchant law firm associated with the efforts they undertook to secure these documents. But I don't yet know what the dollar amount of that is going to be. I will say that I believe that Ms. Merchant's choice of $300 an hour and tying that to the Attorney General's office is a reasonable dollar amount. And that what I will really be focused on is trying to see if, it may be that I'm wrong, right? But to see if expenses or time spent was on something that unnecessarily expanded the scope of the litigation, or was, as Mr. Merchant and Ms. Monroe also pointed out, as to a dismissed party, perhaps not be recoverable. So that's what I'm going to be looking at and determining the nature and extent of any fee award that I make. Questions about what I've just said? Ms. Monroe.
Thank you, Anna, for your breakdown. I'm just wondering if the court will be considering any fees that have commenced that were incurred prior to this litigation.
So that's one of the reasons that I want to look at this issue, because my best recollection as I sit here right now of the standard is that certainly attorney's fees incurred in the litigation beginning when the litigation began is what is directly recoverable. I don't, as I sit here right now, recall what the law is about the things like the drafting of a complaint or things like that, of positioning a case to be filed and whether such fees are recoverable. But it's my intention to resort to the case law. And if there's case law that says those things should not be recovered, then I will exclude them based on what I find in the case law. Anything else, Ms. Monroe?
That's it.
Okay. Mr. Merchant?
No, Your Honor.
Okay. Last thing is, if the...
I just wanted to say I promised you exhibits.
Yes, thank you. If the Gonzalez versus Miller opinion comes out tomorrow and it does in fact say that the district attorney's office and or the elected district attorney in their official capacity are not subject to open records, then I assume I will be receiving a motion to dismiss the case from the county attorney, which will likely be granted, but we might have to mull through it a little bit more than that. I just don't know what it will say. I will be surprised, given Justice LaGrua's decision in the Milleron case and how expansively they were applying the statute there, if they were to very narrowly read it here. But we'll see, because I'm not on that court and I'm not in charge of that. So Anything else that anybody needs from me?
Nothing from the plaintiff, Your Honor.
No, Your Honor.
Thank you all. Have a good day.
All right, all right. We've been here long enough. We've been here for 3.5 hours, and I want to say thank you to everyone who's been here and enjoyed this actual court case. The judge here, I believe she was very fair, mindful, and if they don't get the correct ruling from the appeals court in regards to finding out if the DA office is a separate entity, which is a wild argument, then you know what's going to happen. The saga is going to continue. So at this point, I'm happy. I know a few people in the audience is happy that Mr. and Mrs. Merchant has won the case, and this is a case that is good for the people as well, because as I mentioned to you, even though it's taking place in another state in Illinois, I'm having issues such as similar as these people. So to know that if it gets in front of the proper judge who acts honorably, we will win as the people. How about that? All right. So I want to say thank you again for being here with Grace Levi. Love and blessings to the Levi family. Shout out to Rumble. Definitely hit the like button. Please like and subscribe and share if you like this type of content. And we'll be live tomorrow because Dalton has a board of trustee meeting. All right. So leave your comments. And also I want to say shout out to everyone who was participating in the comments, because that's the most important part about our lives. I want people to be able to express themselves, you know, with respect, but we should be able to talk from all perspectives. Okay. So as I get up out of here, hit the like button.
Answer. Because you are that, you are capable, you are gifted, and you are so unique. All of the things that you may hate about yourself are your strengths. It's okay to be soft. It's okay to be opinionated. It's okay to be different. And it's so okay to just be you. The world awaits to receive you.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Would you like to learn a brand new and innovative way to invest your extra money that has a low barrier to entry and low competition? What if I told you that it is a guaranteed method to get up to 18 to 20% return on your investment? Tax lien and deed purchasing is the only way to get into the real estate market through the back door. No credit and no loans needed. This method isn't commonly taught, and therefore the competition is very low, for now. Put together a 14-hour info-packed course which will teach you everything you'll need to know to get started. Learn at your own pace, step-by-step guided video and aids to start you on the TLC deed investment process. The course offers many learning tools for new investors, helping ensure you safely invest in tax liens and deeds. Contact us today and join the buyback team.